You're breaking up. Yeah, go ahead, Ann. You just broke up a bit there.
Thank you, Judge. Oh, yay.
And you're prepared to switch me to the phone if we need to, right?
Yes, I am.
Okay, fine. All right, great. Go ahead.
Oh, yay, oh, yay, oh, yay. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-3058 et al., United States of America versus Antone White, also known as Tone Appellant. Mr. Kramer for the appellants, Ms. Gabriel for the appellee.
Good morning, Your Honors, and may it please the court.
Good morning.
Since the briefs were filed, the government's 28J letter of October 5th, 2020 has considerably narrowed the issues before the court. As far as I can tell, and obviously I don't speak for the government, but at this point, it appears that the defense and the government agree with the district court that these were covered offenses, so that there's an eligibility for sentence reduction. It appears that the government agrees with the defense that we both disagree with the district judge about the district judge's test about availability of relief. And the government agrees with us that that's not a proper test under the the First Step Act. And so that the only issue I think that's before the court is the district court's indication that in its discretion, it would deny the motion under the First Step Act. So I think that's unless the court has questions about, and I recognize that the majority of the briefs are devoted to the issues that now appear to be agreement between the parties. And unless the court has questions about that, I intend to just focus on the discretionary aspect.
I don't think we do. I think you should go right on to the discretionary issues.
Gee, I hate to contradict the boss here, but
oh, that's okay. You used to be the boss.
old habits, I guess. Okay. I do for two reasons. One, we have two very good advocates here, and I'd like to understand the First Step Act a little better. But the second point is, what do we do with the fact that two of you agree with something that the district court doesn't agree with if we don't hold that the district court was wrong? So if we were to remand it to the district court and not hold the court was wrong, simply that each of you would like to go forward, is that enough? Or could the district court, so maybe I should start with that question. Or could the district court said, well, that's all well and good, but that's not my view of the law?
No, well, I mean, you could remand it to the district court. I think it should be remanded, obviously, on the discretion issue, but I think the district court could say the same thing again, which is I don't think it's available, but if I exercise discretion, this is what I would do. And I think that's our argument, that has to be a fuller.
I thought you were advancing the claim that the district court was wrong on the test of availability.
Yes.
So the fact that the government now agrees with you doesn't change your view that you are bringing an appeal in which you are saying the district court was wrong. Government counsel now says, well, we don't disagree with that. So you would want us to say, I assume in an opinion, the district court's wrong. So when it goes back, the district court has no discretion with respect to that determination anymore if we agree with you.
Yeah, that's the question I have.
No, I think that's right, and I think it's quite actually.
Why would you even hesitate over that? I'm confused.
Well, I mean, you could. The only hesitation I have.
If we agree with you,
yes,
it seems to me straightforward that we would say, in an opinion, that here's the issue that was raised by the appellant. District court went the other way. They're challenging it. We agree with the appellant, and incidentally, the government agrees too. District court's wrong, and on remand, that's off the table.
No, I agree with that. I don't know why I hesitated, and only in the sense that you could just say remand it to the district court and say exercise for more fulsome discussion of the discretion issue. But I think you're right, Judge Edwards. And I think that the simple answer to it is that the First Step Act has nothing about this availability issue that the district court superimposed on the statute. And the government agrees, as I said, that it's only the amounts of drugs either found, in this case, because it went to found by the jury. In a case of a plea, it would be
found by the jury or conceded.
But in this case, because it went to trial, it was not conceded, right?
All right.
The jury clearly found only on the one count of each of those that it was more than 5 grams, and that penalty has been changed, obviously.
Okay, so then if we do need to discuss this availability argument, which is the 404B argument, let me just ask you a couple of questions about it.
Yes.
So what is it? What do you understand the words to mean as if sections 2 and 3 of the Fair Sentencing Act were in effect at the time? What do you understand?
Nothing more than that, frankly, just as if they were in effect. It doesn't say anything about.
Well, what does it mean? What does it mean as if they were in effect?
All I can say is, to me, it means just what it says. There's nothing that says that if you decide that the guidelines would be the same, or that you can't modify the sentence, impose a reduced sentence. Modifies the wrong word. Impose a reduced sentence. It means just what it says. If they were in effect. It doesn't say anything about there has to be a lower guideline range, a lower statutory range. That's in 404A. So,
but when the judge considers whether they were in effect, as if they were in effect, do you think that means that I understood from your brief that you understood the judge may consider the judge found amounts for in making the determination, including for the statutory range. Is that right?
No.
What did you say? So perhaps either I'm not understanding the brief or the brief is less clear than it might have been. I'm sure it's the former, AJ, don't worry.
I'm sure it's the latter.
So at page 28 of the brief, I'm not trying to trip you up here. I'm just trying to figure out what you mean here. It says, of course, in exercising its discretion, a judge may take stock of several considerations, including the judge found amount of crack in the conspiracy.
Yes, I'm sorry.
So what do you mean by that?
That's the stage we're at in this appeal, which is the discretionary stage. In deciding whether to actually impose a reduced sentence, the judge can consider that amount. That's not an amount the judge can. That's it. It says in exercising its discretion at page 20.
No, I understand.
Discretionary phase.
I understand that. So, but if the judge uses the judge found amount to determine in the discretionary stage and looks at the statutory penalty, that's a different question, obviously, than if the judge uses the jury found amount and looks at the statutory penalty in the discretionary phase, right? So if the judge looked at the jury found amount only in the sentencing phase, the judge would see that your defendants have already served more than the statutory penalty, which is 20 years. They served 27 years.
Yes.
If the judge looked at the judge found amount, the judge would find, I think probably the same statutory penalty. A max, I'm talking about, the same statutory max, right?
In the judge found amounts.
Yeah. So are you saying that they can use either one in the discretion, or leave aside the argument about availability? That's not necessarily what I'm talking about here. I'm with you on the question of discretionary, and I'm trying to figure out what is a judge supposed to do in the discretionary phase. And at some parts of your brief, you say what I just said. You say the same thing on page 45 or something like it. I'm going to just find it, so maybe it can help both of us.
I'm sorry, which page?
Well, that one was page 28.
No, right.
The other is page 45. And that says, Appellants do not seek to reopen factual disputes. In fact, they accept the judge found quantity determinations for purposes of their guidelines calculation.
Right.
So are you saying that the judge, maybe you don't understand my confusion, but I am a little confused. At the same time, you say that Apprendi requires that the post FSA range cannot be based on judge found.
All right.
So what is it? So I'm the judge, and the DC Circuit has sent it back, and I know I can have my discretion. And the judge asks, well, can I use the jury? Must I use the jury found? If I must use the jury found, then I should release these people immediately, not just reduce because it's above their sentencing statutory max. If I look at the judge found one, then, and I decide to stay the same, then I don't reduce. So
no, it's discretion. When you say must reduce, we concede that it's discretionary. And the judge, as part of that, the judge can consider the amount and what the guideline range would be, but it's not a disqualifying as judge as the district.
I understand it's not disqualifying. I understand that, and I understand the government agrees with that. Now I'm just trying to figure out, what is the judge supposed to do on remand? You're saying the judge can look at either judge or jury found, either one?
Both, I think. I mean, one argument is that since these two men were sentenced, there's been the Apprendi decisions and the Booker, and the guidelines are advisory, but we didn't challenge the judge found amounts, but they don't affect. They're part of the equation for the judge to exercise their discretion, but they're not in any way binding on anybody.
I understand, but the judge, if the judge says, okay, look, I think I should look at the judge found amounts. I looked at the judge found amounts. Sentence is still within a statutory range and still within the guidelines. So I'm going to stop here. I don't find any of the other considerations terribly relevant. That's one judge could do that. Another judge could say, I'm going to look at the jury found amounts, and my God, this is above the statutory limit and above the guidelines. So, I'm a statutory guidelines person, and I'm going to follow those. And therefore, I'm going to give I don't know, release immediately or whatever. Are both judges acting reasonably within discretion then?
I think so, as long as they take into account all the 35.
I appreciate the other. I'm only just for the moment on quantity. Yeah.
Yes, I believe that's correct. They can consider what the jury found. They can consider what the judge found, but it's not binding on anybody. It's not a must. They could consider it. They don't have to. They can consider any factor they want under the 3553A factors. So yes, I would say both judges, as long as they did a fulsome consideration of the factors, would be proper.
So
And
the as if part doesn't mean that in the discretionary decision making, the judge is supposed to think about as if Apprendi applied or as if Apprendi didn't apply at the time. That is, it doesn't have to. It's within the judge's discretion.
Right. I think one factor, obviously, is that since these two men were sentenced, that the guidelines have become advisory only.
Mm-hmm.
The judge should consider that, it seems to me. Must they consider it? I don't think I would go that far, but it's certainly a factor that they should consider and was raised before the district court here.
All right. I'm sorry to have taken you away from your discretionary factors.
Okay,
argument.
I will just say that for these two young men, I think their tragic childhood, Mr. White was born, his mother was 15 years old. The facts are set out in the briefs. I'm just going to highlight a few of them. His mother was a drug addict in jail. His father was in jail. For Mr. Hicks, his parents drove away when he was 5 years old, and he never saw them again and never knew what happened to them. They were raised in a neighborhood which at the time was rife with drug dealing. At the time they were sentenced, they were 20 and 23 years old. They have spent far more than half their lives in jail. They've spent 27 years in jail. The letters that were sent in their support at the appendix for Mr. White, 388 to 418, and for Mr. Hicks, 619 to 636, are incredible. The way they have mentored, the way they've rehabilitated themselves.
Is your principal argument, I'm sorry to interrupt, is your principal argument, because I think we understand what you're asserting might be mitigating factors, is your argument that the district courts simply did not account for any of them?
Yeah, the discretionary discussion in the district court's 61-page opinion was about a page and a half or 2 pages at the very end of the opinion, which all it did was recite the facts of the offense and said nothing else, said nothing about their ages. And of course, the Supreme Court, they started in this when they were juveniles, and the Supreme Court has recognized recently how the young mind is unformed.
So your principal claim is the court could consider and did not reasonably consider the mitigating factors. And let me ask you with respect to one, because
yes,
I think the two sides are going past each other on the obstruction. The government is pointing to something that I don't think you're claiming. I think you're claiming that the district court, in considering that obstruction, suggested that Hicks himself was involved in the murder, as opposed to what the transcript says. That is, he clearly was trying to affect that proceeding, but he himself was not involved in the murder. And so you're both talking about entirely different things. But in any event, the question I have, just out of curiosity to satisfy myself, the Supreme Court now seems, I think, to make it clear, you're claiming clearly erroneous. The government's claiming plain error with respect to something you're not claiming. You're claiming clear error on the obstruction with respect to what the district court said. And I'm assuming you're assuming that it was preserved. That is, that it was raised with the district court and responded to. But I just looked back at the transcript, but I want to make sure I understand both sides. The government's talking about something you're not talking about, so I'm not talking about that. But with respect to what you are arguing, I think it was, and is that where you think the preservation requirement is met? The Supreme Court now seems to say, even with alleged factual errors, and you're saying this is a factual error on the part of the district court, assume something about his participation in murder that was not correct, and that you're arguing that that influenced the district court, right?
So the district court now said, the current opinion said he was involved in a murder.
Yes,
But
yes.
Judge, the original sentencing judge did not say.
Did not. I understand.
So there was no hearing on this motion. It was all done on the papers.
No, I understand, but you're claiming it was clear error.
Yes.
Okay. By reference to what? There's a transcript colloquy. Is that what where it was raised with the district court judge, and the district court judge? So the district court judge knew you were not raising the claim that the government thinks you were raising, which they say falls within plain error land. You were saying to the district court, he wasn't involved in this is not about him and murder. It's about him and trying to influence that proceeding, right?
Yes.
All right. You're saying that you're raising that with the district court, preserved the question, and the district court then got it wrong in its assumption.
Well, yes. And then the district court in its decision said that Mr. Hicks was obstructing because of his involvement. And that was the end of there was no.
I'm only asking about the preservation. I understand what you're claiming is the error, because I've been a little bit confused. Judge Silverman and I, a long time ago, said that the clearly erroneous rule from the civil side controls and no preservation is required. Supreme Court in Davis now seems to put that completely to rest. There is a preservation requirement with respect to alleged factual errors. I just want to make sure, because the government's not joining you in this discussion. You're claiming it's a clearly erroneous test, and it was clearly erroneous, as if to say you did preserve it.
Yes.
And you're claiming you raised it with the district court then went on and made a determination that was wrong. And that's
Yes.
all you have to do.
Yes.
Okay.
Yes.
Well, could I follow up on that? I'm just, I think if the district court, relies on a fact that is not true, it has to be remanded. So I care less about this standard of review question, maybe than Judge Edwards does at this moment, but I'm not sure about the answer to his question. So you raised in your sentencing memorandum the points about rehabilitation, childhood, et cetera, correct?
Yes.
Okay.
Yes.
Then the district court said, erroneously in your view, in the opinion, because there was no hearing, no elocution, nothing,
Right.
said that your client Hicks, that the obstruction involved his participation in a murder, right?
Right. I think yes.
No, not just his involvement.
Participation was the word used. Yes.
Something like that. And then you did not have an opportunity to respond after. That is, there was no opportunity for you to correct the record by saying, unless you filed a motion to reconsider or something, right?
Right.
I think we pointed it out in our papers, actually, that
Papers at the before the judge's ruling?
Yes.
In the reply brief.
That there was that the
I think it was in your reply brief to the district court.
Yes. Yes.
What was a reply brief after? This is in response to the government misunderstanding the facts. Is that what you're saying?
In the government's opposition to the First Step Act motion.
Yes.
Then they argued that it was about his involvement in murder.
I see. Okay.
Right.
But it was not.
Okay. So then you joined that issue and disagreed in your reply papers with respect to the sentencing. Okay. Great. All right. I understand.
So I just want to say that there was that both their age at the time, their circumstances, the incredible letters about their rehabilitation and their mentoring of people in prison, their support from their families and friends, job offers if they were released from prison. For whatever reason, I mean, there is no indication the district judge considered any of that.
All right, Mr. Kramer, let me ask you one other question. What do you understand the district court did in its alternative holding? Did it use judge-made findings, jury-made findings of quantity, neither one, both? Did the judge, given what the judge had previously said, did the judge understand what you believe to be the law? I take it, I think the government also now believes that the judge could have used the jury found quantities.
The current district court said no, it was all the judge found quantities.
But when they said in the alternative, when the district court says in the alternative, which I take it to be some kind of even if argument, even if what? That is, when the district court ultimately applies discretion, I don't see any indication one way or the other about whether that included an acknowledgement of being able to use jury found findings.
Well, I think the judge rejected any, idea about the jury found findings at the availability stage.
Yes, but then when the judge moved on to, okay, I'm going to give an alternative holding here, essentially, right?
Right. Yeah. Well, the district court has said Elaine and Apprendi don't apply.
Yeah.
This proceeding. So clearly, the judge was using the judge-made facts, found facts.
So is part of your argument for a remand not only the argument that you were making a moment ago, but also that the district court didn't understand that it could have relied on the jury found quantity for purposes of sentencing range and guidelines.
Absolutely. I mean, she had, so to speak, pretermitted that fact by finding that at the availability stage, so that it was essentially irrelevant at the discretionary stage. Yes, absolutely. That's an argument that one of the things that I said earlier, that it changed now to the advisory guidelines, and that jury findings set the statutory range, would set the statutory range now. So that was.
But she didn't, Mr. Kramer, she didn't say that. You're assuming that because she took it off the table at the availability stage, that when she said in the alternative, I would do X, that was that she must have assumed that she couldn't rely just on jury quantity, right?
She didn't say one way or the other. You're absolutely
She
right.
didn't say.
Yeah, okay.
But she
But that's
didn't
why you
mention-
think it should be remanded on this issue, because we don't know the answer to that question, correct?
Yes. I
Okay.
think that's the point of the whole remand. All of these, that was one issue we argued, that she should consider that the
Okay.
whole sentencing structure had changed along with all these mitigating facts, and none of them are mentioned
Okay.
in the
All
discretionary.
right. I think Judge Garland or Judge Edwards, do either of you have any more questions at
No,
this point?
Nope.
nope.
Thank you.
We'll hear from the government, and I'll give you a couple minutes for rebuttal.
Thank you, Your Honor.
Okay.
Good
Ms.
morning.
Gabriel is now unmuted.
Can you hear me now? Yeah. Okay. Good morning.
Sound like a commercial.
May it please the court, Elizabeth Gabriel on behalf of the United States. I do think, as Mr. Kramer pointed out, that we are in agreement on a lot of issues in this appeal, and that the court need not decide some of the more difficult Section 404 issues, because it can't uphold the district court's judgment on the discretionary ruling. I'm happy to clear up what the government's position is, if there's confusion on that, and to discuss further what we think the mechanics of a Section 404 proceeding should be, if the court would like me to address that. Otherwise, I'll just talk about the discretionary ruling.
I think we're back in the same posture that Mr. Kramer began, and that we wouldn't let him stick to. So
Okay.
I'm going to have to ask you to do the same.
Sure.
So tell us exactly what is the government's position now.
The government's position now is that because appellant's offenses were violations of Section 841 B1A 3 and B1B3, that those offenses are covered offenses for purposes of Section 404, and that they were eligible for consideration for a sentence reduction. Now, we agree with appellant that the district court should not have considered the judge found quantities in determining what the statutory range would have been if Sections 2 and 3 of the Fair Sentencing Act were in effect in terms of the 404B analysis. So at that phase, we think that the judge should only look at the jury found or admitted quantities. But we agree with appellant that when it comes to deciding whether to impose a reduced sentence, in considering all of the 3553A factors, the court can and should consider the totality of the conduct, including all of the total amount of drugs, whether found by the jury or not. And so at that point, the total quantity would come into consideration.
So this statement in your letter, I'm just going to try to pull it up here for 1 second, which says the position of the Department of Justice is that Section 404B contemplates determination of the statutory penalty range based on the quantity of crack cocaine reflected in the jury verdict or admitted by the defendant in a guilty plea. You mean that only with respect to this argument about availability, and not with respect to the to the way in which the judge acts in the judge's discretion?
Exactly. So once a defendant is deemed eligible because he has committed a covered offense, the district court has to figure out how sections 2 and 3 of the Fair Sentencing Act would have affected his sentence. In other words, what the statutory range would have been had the Fair Sentencing Act been in effect. In reaching that determination, that question, the court looks not at judge-found quantities, but only at jury-found or admitted quantities. So we think that the judge-found quantities should not be relied upon in determining the applicable statutory range. But then once that is set, the court has to decide in its discretion whether a reduction is warranted.
Well, I have the same confusion, I'm afraid, I had with Mr. Kramer. So if you have to use the jury-found quantities in determining the sentencing range, when you go to discretion, we're above the jury-found. We're above the sentencing range now under the jury-found quantities. So what is the district court supposed to do at that point? That would seem like the district court, yes, has discretion, but should realize that the person has served longer than the statutory range. And in which case, maybe it would be an abuse of discretion not to release the person. Why is that wrong?
Well, I think simply because the total quantity would elevate the guidelines range, for example, above the new statutory range, doesn't mean that a court abuses its discretion if it decides not to grant the reduction. Again, at that, once the court determines—
Wait, when you say reduction from what? Because the statutory range is below the guideline range.
Right, a reduction from the sentence that was originally imposed. So because ultimately the court has to consider the totality of the circumstances, all of the factors under 3553, the court can weigh those factors differently. It may decide that, well, the total quantity of drugs doesn't outweigh other considerations, or as in this case, the court concluded that the nature and circumstances of the offense do outweigh other considerations. And so in the court's discretion, a reduction wouldn't be warranted.
So, I mean, to answer Judge Garland, you're essentially hypothesizing the district court judge looks at a case and said, these folks under the statutory range should be released. But I now am going to exercise discretion to increase what appears to be the statutory range. And the reason I'm doing it is that what you're saying? In other words,
yes.
So it's not a matter of whether it's being reduced. What you're positing is the judge wants to exercise discretion to reach this result to see whether the sentence should be increased above the statutory range.
Well, we wouldn't look at it that way.
Yeah, but I mean, as a real life matter, that's what this really is a little bit more perplexing than I realized. That's essentially what you're saying. If we look at it as of assuming the statute was in place, and you're agreeing that statutory range, you have to take what the jury found. Statutory range now is exceeded. They've done their time. So the question before the district court now is, do I enhance? And if so, why? And the other side's arguing, not only don't we think you should enhance, we think there were reasons to go lower. So wait, how are we resolving this mismatch?
Well, I think that the critical factor here is that under Section 404, any reduction is discretionary. Defendants are not entitled to reductions.
I really am sorry to interrupt, but I got to make sure I'm following. When you say any reduction, remember, I'm having trouble with the word reduction now.
Oh, let me see if I can help for a minute. I understand you, Gabriel, to be referring to 404C, which says nothing in this section shall be construed to require a court to reduce any sentence pursuant to this section.
Yes.
So the
Okay,
reduce you're
all right.
talking about is to reduce from the original
From the
sentence.
original
Yes.
sentence. Okay.
Yes. I'm sorry if that was unclear. Yes.
Okay, no, I want to make sure. I remembered C, but I want to make sure that's what you were talking about. Okay,
Yes.
I'm sorry for interrupting.
Yeah, the way I conceptually think about this is sort of in a two-step process, but it ultimately is a discretionary decision, and because
To reduce from the original
from
sentence.
the original, exactly,
Okay.
because defendants are not entitled to reductions under the First Step Act, the court has considerable discretion to consider the nature and circumstances of their offense.
And does the court have so as I understood Mr. Kramer's position, the judge has discretion to either look at judge found quantities or jury found quantities or both. You agree with that as well?
Once the statutory range
yes.
is determined, yes.
I
think that's correct.
Yeah.
I think that's correct. We would, of course, the government would argue that the judge should look at the full range of conduct.
Right. But do we know whether the district court in this case knew that it had that ability? Because, given the shifting views of I'm not blaming the government about this, but given the changing views and the judge's sort of first two steps of the analysis, this is really the question I put to Mr. Kramer before. Do we need to remand at least, leaving aside Mr. Kramer's other arguments, which you'll get a chance to respond to in a second? But sorry, Mr. Kramer, but it's really good on Zoom. I can see your facial expressions perfectly. Is it, and I think as Judge Tatel put it, it's pretty hard to know what the district court thought, because at that point of the district court's opinion, it's only about the exercise of discretion. There's no discussion of quantity.
Right. Well, I think that the court's opinion is very detailed, obviously, and very lengthy and well-reasoned. And the court starts out.
But Gabriel, not on this issue. It's not.
Well, I do want to just explain why I think a remand isn't necessary. The court starts out her written decision by discussing the views of appellants and recognizes that appellants consider their new statutory range to be 0 to 20. And that's how the court sort of frames the discussion. Now, Chief Judge Howell goes on to explain why she disagrees with appellant's view. But then when she reaches I'm sorry, go ahead.
Take this into account in answer to the question my two colleagues raised. The district court judge references the quantity in the discretionary portion of the opinion. She's referencing only the judge found quantity, only. So my assumption was she is not assuming that the jury found is in play at all. There's nothing to indicate that she either bought it or realized it at all. The only thing she references in the discretionary part is the judge found quantities, right?
That's correct, but I do want to explain why I think she considered the appellant's position, because she then, once she goes through what she thinks Section 404 means and how it should be applied, she then says, well, even if I'm wrong, essentially, even if appellants are entitled to relief here, even if relief is available, and implicit in that assumption is that, even if I'm wrong about Apprendi and Elaine, that I still would not grant a reduction. So I think that
wait, you know what I read her to be saying on that point? The even if, I thought she was saying, doesn't matter because they're not going to do any better. And they're not going to do any better because she's assuming the judge made quantities control. I thought the thrust of her opinion, what waste time on discretion, they're not going to do any better, because when I look at the judge made quantities, they're in the same place. That's the way I read her opinion. I did not see anything to suggest that she understood they would be better off if she used the jury determination, and she was rejecting that too.
Well, the way that I understood it, Your Honor, was that she, in that, her even assuming language is a reference to, even if even assuming that I was wrong in how to calculate the statutory range, I still, and in other words, even if appellants are right, that in fact they are entitled to consideration for a 0 to 20 sentence, I still, considering the 3553A factors, would not grant a reduction. So yes, she refers to the judge found quantity in that section, but only as part of her 3553A analysis.
But you agree that the reading that I'm suggesting is as plausible as your reading of the district court, right? Because she's only referring to the judge made. And the worst or best that we come away with is we're really not sure. Right?
Well, I agree with you that she only refers to the judge found quantity, but I don't think that it means that she misunderstood her discretion.
No, we don't even have to go that far. If the appellate court really is not sure with the district court judge, I don't have to go further than that. If I can honestly say the view you're propounding, I get it, but the view that's in my head, I get too, and I don't know which way to come out. If I'm confused, where does it go? It goes back.
I understand Your Honor's point, and again, the government's position is that we don't think that there's a lack of clarity in the decision, but I do understand the point you're making.
Okay, thank you.
I can turn to I would like to comment on the obstruction issue, if the court would permit me.
Before you do that, Ms. Gabriel, let me just ask you. My internet was breaking up when you were responding to Judge Edwards' question about where he said, look, if I can't tell what she did, it has to go back. I heard you say, I understand, but did you go further and say, did you say what you think about that? Why isn't he right about that?
The government doesn't believe that there's a lack of clarity in the court's opinion.
Correct. I know that, but if the court thinks there's a lack of clarity, isn't Judge Edwards right about that?
I suppose that if the court thinks that the district court could not have properly exercised its discretion because it didn't understand the mechanics of Section 404, a resentencing or a reduction of sentence, then yes, the court a remand would be appropriate to set the record straight.
I just want to be really clear about that. We don't have to conclude that she misunderstood.
Right.
All we have to conclude, I hear you agreeing with Judge Edwards, is that we can't tell one way or the other. I understand your position is that it is clear, but you're a good lawyer, you're arguing your case. But if we think that if we read it and think there is uncertainty, then you agree it does have to go back. And that to do that, we don't have to find that the district court misunderstood this, right? It's just uncertain.
Right. I think that's correct. If there's uncertainty, a remand would be appropriate.
Okay. Yeah. Miss, thank you very much. That's very helpful. Why don't you go on to the other issues now?
Okay. Just quickly on the obstruction issue. I did not read appellant's reply brief as addressing whether this issue of whether the grand jury was investigating Mr. Hicks for murder. The reply brief, as I read it, it makes clear what murder was at issue. But the PSR indicated that the grand jury, that the witness whom Mr. Hicks bribed was investigating White and Hicks for a murder. And so I think the district court was entitled to rely on that representation. And I don't think that it was preserved in this Section 404 proceeding. Once the district court ruled, I think it was incumbent upon appellants to raise an objection, either through a motion to reconsider, a motion to correct, in some form or fashion. Appellants were required.
You haven't raised that. And
we argue that plain error applies because.
No, you're arguing plain error applies with respect to something they're not asserting. And maybe
I misunderstand.
That clear. They're not asserting what you're claiming. They are claiming that the district court misunderstood in characterizing the obstruction charge misunderstood in the sense the district court assumed that this was about a murder that Hicks was involved in, not a murder investigation, or that he did something bad in connection with a murder investigation.
Right.
It was
and
as if
I
to
think-
suggest, it was as if to suggest that Hicks himself was the subject, and they're saying that's not correct, and the district court shouldn't have assumed that, and that would have affected the district court's thinking if she really assumed that that's what was going on.
Right, but I think that claimed factual error, which is underlying the district court's decision,
Right.
is a claim that should have been brought up.
Oh, I thought in the transcript, and I mean, I will certainly go back, but just so you understand what I'm assuming, in that colloquy with the district court, I thought that the.
Wait, I'm sorry, Judge Edwards, I don't have a transcript. What
I
colloquy?
can't find the page.
I don't think there was no transcript in the
No,
404.
there was, I'll have to look for the citation and I'll tell you what I'm talking about, okay?
Okay. Either counsel, there was no oral discussion. There was before Judge Green, but not in this case. Yeah.
Right. And I think that even if and I know that at the sentencing hearing, Mr. Hicks's counsel, made a general statement that he wasn't involved in any murders. I don't think that preserves a claim in this Section 404 proceeding, however.
What about the district court's opinion in the 1993 opinion, in which the court says, this is in trying to discuss the unavailability problem with respect to hearsay, that as to Hicks, you can't use the hearsay because he wasn't involved in causing the unavailability, namely the murder.
Well,
Isn't that a finding by the district court that that is by Judge Green, opposite to the decision in this case, which says that they were investigating him for murder?
Right.
Right. And I think that the distinction is that statement refers to is a general statement about his actual involvement in the murder. But what's at issue here is whether the district court erred in finding that the grand jury was investigating him for his involvement in murder. And
no, I think that's where you're misjoined. I didn't read them to me making that argument, but in any event, okay, I'm trying to find the pages. Go ahead.
Okay. As I understand it, they object to the district court's ruling in this case because the district court's finding as to obstruction, his obstructive behavior, was based on the assumption that he had bribed, or on the finding that he had bribed a witness who went to the grand jury, and this is what the district court's written opinion states, withholding information from the grand jury that was investigating him for murder. So the critical question here is, as I understand Appellant Hicks to frame it, is whether the grand jury was investigating him for murder. And I don't think that anything in the proceedings in 1993 or in the Section 404 proceedings preserves their objection to that factual finding here. Again, this distinction I'd like to make is we're looking at what was the subject of the grand jury investigation. In any event, we don't think it matters because ultimately the district court was relying on his obstructive conduct, and Appellant Hicks doesn't dispute that he in fact bribed a witness who was going to the grand jury. And that's really what was the critical conduct that the district court in this proceeding relied on in finding that a reduction in sentence was not warranted.
Ms. Gabriel, if we think, going back to the first question, if we think that there is uncertainty about the question of whether the district judge, if we think there's uncertainty about whether the district judge thought she could rely on, had to rely just on jury found, do we have to address this issue for Hicks? Doesn't this go back on that too for him?
I think that's true, yes.
Yeah, okay, all right. Thank you.
Okay, if the court has no further questions.
I don't have any,
Yeah,
the only thing I just want to make sure, just as I did with Mr. Kramer, that I understand the government's position in sum, and that is that The violations here are covered, that the 404B discretionary reduction is available. And in that discretionary decision-making, the judge can use either judge found or jury found amounts. Although, of course, you would argue that she should use the jury found, but in terms of permissibility, it would be permissible to use either one. Is that right?
Yes, just with just to clarify, that's after the statutory sentencing range is determined under the Fair Sentencing Act.
So does it have to be determined, or that is, does the judge have to announce this is the new statutory range, or is it just a question of whether the act applies? I didn't realize there was a step where it's required to actually have the judge make some determination.
Well, 404B requires the court to figure out how the Fair Sentencing Act would have affected the sentence. The term "as if," this phrase "as if" sections 2 and 3 of the Fair Sentencing Act were in effect, requires the district court to figure out what that effect would have been. And so, because a court can't impose a reduced sentence unless it makes that determination. Otherwise, any reduction would not be as if sections.
So then your view is that in making that as if determination, the judge has to use the jury found to determine the range, and then thereafter can use either one in its discretion.
Yes.
Got it.
Yeah. Okay.
Okay, thank you.
Well, thank you very much.
Yeah, thank you. Mr. Kramer, you can have 2 minutes.
Maybe you, well, since it's on your side, would you please do me the favor of, I can't find the pages right now. They're in the 404, and I thought it was in the context of the 404B proceeding. Where did the judge misstate the matter, in your view, with respect to the obstruction? And where did defendant say something to suggest you got it wrong, Your Honor?
So at page 59 of the district court's opinion, it says Hicks engaged in obstructive conduct to withhold information from the grand jury that was investigating him for murder.
Investigating him for murder.
For him for murder.
That's what I remembered. All right.
What I would like to point you to is appendix page 282, where the government, this is from the government to Judge Green, saying what the obstruction of justice was for Mr. Hicks was he bribed Mr. Hicks, I believe he said means Mr. Jackson. He bribed not to give information to the grand jury in the form of money and crack. They don't say a word about murder there, which clearly they would have if about Mr. Hicks being involved in murder. That's
Mr. Kramer, is this a direct response to the question of whether the grand jury was investigating him for murder? I understand the government's position to be, okay, the obstruction count may be different. Okay, the district court may ultimately have made a decision that Hicks wasn't involved. But the only question here is, was the grand jury investigating him for murder? And do we know one way or the other about that?
The defense lawyer had given a talk about how Mr. Hicks was not involved in any murders or violence.
Not involved, but what about whether he was being investigated? That I understood was the government's question.
Right, and the defense lawyer said it had nothing to do with Mr. Hicks being involved in any murder, and this was the response to that by the government, that the bribery on page 282. I just want to say two more things. The mitigation here is extremely powerful, and the Supreme Court has said in Pepper that a defendant has a right to have post-sentencing rehabilitation considered when there's a resentencing procedure. There is no indication the judge considered any of the mitigating circumstances, and that her decision on how the jury found facts were irrelevant. It was the judge found facts that would drive the guidelines range and the statutory range seemingly colored her view of the discretionary phase. And then I just want to say one last thing. It's extremely important, especially in this case, to be certain, because under the First Step Act, the defendant only gets one shot at it. They are precluded from filing a second First Step Act motion. They're precluded from any relief by Section C, which says if a previous motion was made and denied after a complete review of the motion on the merits. I guess our argument is that this wasn't a complete review, but in any event, it's extremely important because they cannot have another chance to file another First Step Act motion the way it's currently written. Thank you very much. We would ask you to read the case for further consideration. Thank you.
Mr. Kramer, Ms. Gabriel, thank you both. The case is submitted. Let me just ask, before you call the next case in, since we went over on this, would either of my colleagues like to take a break before we start the next case?
I'm happy to wait for after the next case.
Okay, fine. We'll take a break after the next case. Great. Go ahead.
Thank you, Judge. Case number 20-5193, American Hospital Association et al., Appellants versus Alex M. Azar II in his official capacity as Secretary of Health and Human Services. Ms. Blatt for the appellants, Ms. Dixon for the appellee.
Thank you, and may it please the court. My name is Lisa Blatt, and I represent the hospitals challenging the agency's price disclosure rule, which, absent this court's intervention, will go into effect on January 1, 2020. Hospitals wholeheartedly agree that patients should know their out-of-pocket costs before receiving health care. But this rule does not achieve that objective and is also invalid. First, the statute forecloses the agency's interpretation. And second, the rule violates both the First Amendment and the APA because the rule is unworkable. It requires hospitals to misinform their patients, and the rule grossly misapprehended compliance burdens. If I could start with the statute. A requirement for hospitals to list their standard charges for items and services unambiguously refers to the gross charges that appear on hospitals' charge masters. Those are the only default asking prices that universally apply to all payers. This was such an obvious conclusion that the agencies in 2004 went through a rulemaking, taking it for granted that the statute referred to the gross charges.
Isn't your position on appeal, though, Ms. Blatt, position on appeal that I thought you conceded on appeal that this is ambiguous? In the district court, you argued it was clear, but isn't your position here that it's ambiguous? Don't you concede that?
No, I think in a couple places in the brief, we say it's unambiguously refers to the gross charges. Now, the key thing, though, which is I definitely agree, the emphasis on the appellate brief is that the interpretation fails step 2. But I do think it's important that the step 1.
I'm sorry, my internet is spotty. Could you just repeat what you just said?
Of course. So the brief, yeah, sure. So the brief makes 2 arguments, both that the statute is unambiguous and that even assuming there's ambiguity, the rule would fail step 2. And I was just saying, I think the step 1 arguments are important because they certainly do go a long way in undermining the agency's interpretation under step 2. And it's significant whether it's.
What do you do with the second phrase, the including phrase in the statute? Because
so
the government says, look, including, it says, I mean, it says standard charges include charges for DRGs. So by definition, plain language of the statute, standard charges are not limited to gross charges, right?
So standard charges for items and services are limited to gross charges. And the including phrase is not being used illustrative here because by definition, and the government concedes this, charges for DRGs are not by definition charges for items and services. So this language, the including language, is in here because the items and service language would otherwise exclude it. And so the government tries to use that including to say that you can interpret the statute to mean payer-specific negotiated rates. But that is incredibly implausible that the Congress would refer.
Wait, I don't think grammatically that's the way the sentence works. It says, the way to read this sentence is a list of the hospital's standard charges, ... including 4 diagnosis-related groups. The 4 before DRGs tells us we're talking about charges.
Sure, I think that's fair. I think, though, what the statute is doing, because, again, we know by definition that it's not an items and services. But I think let me get to the more fundamental problem with the government's reading. The government may get you somewhere in saying that that injects ambiguity, although we don't think it does. But if you go there and say it's ambiguous, it doesn't allow the secretary to go to all payer-specific negotiated rates. And here's why. That reference is referring to a non-negotiable preset DRG rate by Medicare. And what the government tries to say is, well, that creates an ambiguity that allows us to get to all negotiated rates, not just the ones that aren't negotiated, for all private payers and rates that have nothing to do with DRGs. And so I don't think that helps them. But if I could also get to...
Well, but it says, the word is including. It doesn't say only. It doesn't say, the statute doesn't say each hospital operating, it doesn't say a list of the hospital's standard charges for items and services provided by the hospital and for diagnosis groups. It says including. So obviously it's a broader category.
Well, the example we give in our brief is
standard charges is broader than just, right?
So
I'm just looking at the language of the statute.
Sure, and the example we give in our brief is that you could have the language of a statute that says states include Puerto Rico. And that is use the word including, and it's not being used illustratively. It's just doing in contraindication to what the statute might otherwise say. But whatever, the problem with even if you think that there's some ambiguity in there, there's still 3 problems with trying to say that a standard charge means all payer-specific negotiated charge, because a standard charge still requires some representative charge, and each and every individually and specifically negotiated rate by definition is not representative. It's bespoke, it's customized, it's the unordinary and the customized rate. It's just not representative or common or ordinary. And second, there's no question that this statute requires disclosure of knowable numbers. You have to know the number in order to disclose it. And many negotiated rates just don't have knowable numbers. They rather depend on complex algorithms that would vary depending on patient care. And that's simply a problem that the Department of Justice never addresses. And the third problem with this, and I think this goes back to the step 1 argument, is that this is an unprecedented disclosure regime. It really is. And it's implausible that Congress intended this provision of the Affordable Care Act to usher in a sea change in industry practice without anyone noticing until 2019. The agency went through 2 rulemakings, one in 2014.
Well, can I go back to your statutory question for just a minute, the earlier one? Under your theory, if this were limited to gross charges, am I right that would result in disclosing charges for only about 10% of patients? Is that right?
So there's no question that
is that right?
So
is that right?
So you're right that patients do not largely pay gross charges because most patients are covered under Medicare or insurance. What is also correct is that the statute isn't directed to what patients pay because hospitals would never know that. So there's no question the statute can't be talking about patients out-of-pocket costs because hospitals, of course, don't have the patient-specific information.
So my only point Yeah, but, right, so it won't cover, under the government's theory, under the government's regulation, it won't include everybody, but will include a lot more than just 10%.
Well, it doesn't
And my
include,
reason for asking the question is, isn't it perfectly reasonable for the government to interpret this statute in such a way that it promotes the maximum amount of
no,
disclosure?
it doesn't tell anybody anything. So we can get to that under the APA, but in addition to, I mean, we could talk about it, but just on the negotiated rates, but each of this, it really tells no one anything. But the one thing we know is it doesn't tell consumers. This is supposed to be just directed at what hospitals can disclose. The rate has to, again, be knowable. And many rates are unknowable. So already you have a incomplete database and the government's rule just doesn't address it. It doesn't speak to it. You have no clue what the government thinks about it unless you hear a post hoc representation for the first time in the response brief, because the rule doesn't address this. The rule also is completely silent to all rates that aren't itemized. So many rates appear only as a package or a bundle. Again, the rule is completely silent. The agency was inundated with comment after comment saying this is how rates work. Negotiated rates don't come in these unique, itemized way that the government envisioned in the rule. The rule doesn't speak to it in the final rule. The government's brief is completely silent on the first problem, although it addresses the second problem in a way that creates more questions than it answers. And I
want to ask, finish, I'm sorry.
Sure. I mean, this is devastating to their whole entire justification, is whatever they say is, aren't we doing something? Well, how would you know? Because the agency has never told you how this rule is even workable or could provide any consumer any information if the database is both incomplete and misleading. Now, in the government's brief, for the first time, it says, hey, hospitals, if you have itemized or bundled services like a hip replacement, just put NA for non-applicable in the database. So that the hospitals heard that for the first time. They still don't have any way of knowing what to do about rates that turn on patient care. So they have no clue, but they say put NA. So there are two problems with that. First, that is very misleading because it indicates to consumers that the item is not covered on the insurance plan, which turns the purpose of the rule upside down. And second, the agency still has to grapple with the problem. You can't make this up in your opinion, and the government can't get up here in the first time and try to explain how the rule is workable when hospitals have never been told and have never had the opportunity to comment. Actually, they commented, and then the agency just ignored the comments. If I could also talk about the fundamental argument about what you were saying, Judge Tatel, that they could at least know something because they could look at, for high deductible plans, they could at least determine, assuming incorrectly that you would know something about negotiated rates, they could at least look at what's called the discounted cash price. So our argument under both the First Amendment and the APA, and this is a very, very serious problem for the government. The rule recognizes it requires a discounted cash price. That's one of the 5 definitions of standard charges. The rule recognizes that many hospitals just don't have a standardized cash discount. They rather have individual discounts based on sliding scale for financial need and individual charity care and bill forgiveness. Now, what this rule does is it tells hospitals to falsely report that their discounted cash price is the undiscounted gross price for the service. Now, that perniciously says to uninsured patients that the only way they can get healthcare is to pay a gross price, what the government is going to get up here and tell you, and what Judge Tatel, you just indicated, is some inflated price that no one pays. So that is just pernicious and it's perverse. Now, the government's HHS doesn't dispute this in the rule, and you know why? Because they don't address it. They're just silent as to this serious problem, even being told by hospital that it would deter patients from seeking care. Now, the government's brief tries to rehabilitate the rule by citing to a different statement, I think it's page 547 of the rule, that is addressing a different problem of misrepresentation as to confusing patients with just, the document data up and negotiated rates. And that part of the rule on 547 says, hey, nothing stops the hospitals from issuing corrective statements through patient counseling. Well, the problem with that is that they block you from putting a corrective statement in the only place that would make sense, where you're making the misleading statement. So when you have to post gross price for your discounted cash price, when you in fact have discounts, it's in a spreadsheet. So it's machine readable and you can't put any disclaimers or long text explanations. So you have this very misleading statement saying discounted price equals inflated gross price. That's wrong. And then you have the problem of all the negotiated rates being either proliferated with NAs or just no one still knows what to do. And
Could I ask a question?
oh, sure.
Yeah.
Yeah.
Good.
So I really want to go back again to this statutory text and to the charge masters. Now, when it says each hospital shall make public a list of the hospital's standard charges, are those previously those were the charge master charges, right?
So just let me just clear up a little bit. So they are they're the gross charges, and charge master is just
When you say gross, you were required to list a charge master list. Is that right?
yeah. So the gross prices are what the charge masters contain. So those
Right.
are list prices. They're
Okay.
the maximum.
I got it. And those are, in your view, standard charges. Is that right?
Yes, which was what the Obama administration said.
I don't need a modification of this. All I need is
Yes,
your client believes those are standard charges. Is that right?
yes.
Okay. Now the decision below, the district court says the charge master rates are highly inflated, often bear little resemblance to the actual payment tendered to a hospital by a patient or a third-party provider. One study found on average insurers and patients paid hospitals only about 38% of the amounts on charge masters. Is that true? Those facts?
Yeah, we don't dispute that, but here's what we do dispute.
No, I'm not.
Yeah, we don't dispute
I
it.
don't want you to pivot. I don't want you to move to a different argument. Let me just pursue this argument first.
Okay.
And then I'm sure Judge Tatel will let you make whatever other arguments you want to make. So why wasn't that a violation of the First Amendment, a violation of the statute? If these are not charges that many people at all pay at all, and if in fact they contain false information, why do you think those are the appropriate kinds of charges under the statute?
So they're not, first of all, they're not false, because for time immemorial, and this is in the rule, that gross charges are the asking price that apply to all payers. So they anchor all negotiations, and they are the maximum. This gets to your First Amendment point. They are the maximum allowable cost that any patient. So if you've got a bullet wound or bad car accident, that gross charge is the price.
So a maximum charge would be regarded as a standard charge.
The maximum, it gets to your First Amendment point. The standard is it gets to the universality of it. So no, we're not defining standard as maximum. I thought you were asking why the gross project.
I'm asking both questions. I want to know why the gross charges are standard under the statute.
Okay.
And why they are not in violation of the First Amendment on your argument that they are misleading.
So yeah, let's take just the statutory argument. Our definition of standard is model, default, universality, and representative. The only representative charge, the only universal charge, is the charge master charge. Not only because it's the maximum, because it anchors all insurance negotiations. So it shows you that if nothing happens, in the absence of anyone uttering anything, the hospital's asking for the list price. So it is like your standard rack rates or the MSRP or a hotel room rate. It's the published advertised charge. So I think that's why. And if I could just explain, I think it gives this is why I do think it's important as a common sense matter that the 2014.
The government's response to that is that's not the way the hospital business operates.
I agree.
There isn't one price. It's completely different. And to use menus or hotel rates as a model is to miss entirely the way this industry operates.
Yes, and I'm going to get to this point again by the whole 10-year history of interpretation. What the government has said throughout the 2014 rulemaking and the 2018 rulemaking and this rulemaking is here's why a disclosure regime that requires gross charge disclosure is so great. So what the government tells you in the rule, I think it's at 540, is that disclosures of gross rates promotes price competition and brings down the cost of patient health care. And here's why. because it tells the uninsured patient its maximum allowable price. And it allows insured patients to comparison shop, because the starting price is at least somewhat proportional to the ending price. So you can look at two different hospitals and see that one has a really high gross charge starting asking price and the other one isn't. But whatever you think of the word standard, the government has no definition of standard charge that doesn't include any price. Any charge is a standard charge in their view, because standard means specific and charge is not limited to the government's asking price. So there is no such thing. And you can say it's a unique market, but you still have to define standard and charge, and it can't mean everything, particularly when the numbers were unknowable. Now, if I could just get back to the First Amendment and just why isn't this misleading? Again,
Sure.
I think that there is some common sense element to the fact that two administrations thought that this meant the charge masters, and that's what hospitals were doing, shortly after the passage of the Affordable Care Act. And the agency went through two rulemakings. And when the agency went through its second rulemaking in 2018, it never said, hey, we're proposing negotiated rates. It said, maybe standard. Would everybody like to comment whether standard could mean average or median? So this wasn't even raised as a possibility either in the 2014 or the 2018. Now, why it doesn't violate the First Amendment, which is a wonderful question. So I do think that it passes, I think, any level of scrutiny, that when you have a buyer-seller reaction, the government is allowed to prevent the following scenario. You can buy my house, but I'm not going to tell you the price. And then you say, okay, and then you list the price. So it's always okay for the government to compel you as part of offering a service in a transaction that if you accept, here's the maximum price you will pay. And so I just think that's been a given in First Amendment.
What do you mean I'm not clear. What do you mean if you accept? I understood that you had to list the charge master charges. Isn't that right? Not just tell a patient after the patient is accepted. They had to list them, right?
Right. So what I'm saying is that list, just like any list of any pricing, communicates that if nothing else happens, in absence of any other circumstance, that's the price you will be charged.
Is that what it says? Those qualifications that you just gave, are all of those qualifications on the list, or is it just a charge master list?
So a charge master list is not something that had been published before. So this was a big deal when the government in 2014 said, you got to do this. So it did not come out until 2014. And these charge master rates were known to insurance companies, but this was why the government, including today, wanted to get this information out there, because it would at least communicate to patients what their maximum allowable charges. Because
right.
Otherwise,
but the caveats, the explanations, which you said don't.
Oh, about the discounted?
No. In order to not be misleading, that is, in order for the patients to not think they're actually going to have to pay the charge master rate, there has to be some explanation with it that says, this is the gross charge. And otherwise, it's going to be misleading, right? This is the gross charge, which may be reduced under certain circumstances or whatever, right?
And I think that's a problem then the government should have addressed. Now, I think—
No, just hold on a second. So with respect to the charge master list, which you think is okay, is there a bunch of caveats that explain to the patient what it means?
No, but remember, this statute is not directed at patients. This is
Okay, can I ask you? That's what I thought you were going to say, and therefore I want to know why you think that. So it says a list that shall make public a list. Well, what's the point of make public a list if the list is only going to insurance companies?
So I think and this was, I think, a point we were trying to make in the 28J letter, the government acknowledges that customers aren't going to read this list, that it's only being done as a computer spreadsheet database in the hopes that some hypothetical third-party vendor may surface that will then turn this into apps. So this entire list that we're talking about with the discounted cash price and all the negotiated rates by plan, by location, by inpatient, outpatient, is all in a machine readable spreadsheet.
No, I understand that too. I'm still, I hate to say this, I'm stuck on the statute, okay? So, I'm a real textualist here. I'm trying to read the statute. What makes you think that the purpose of this statute was not to communicate information to consumers. Is there some I mean, I would have thought when I saw this, that this is an effort at transparency with patients. Maybe not a good effort, maybe not a perfect effort, maybe not even a constitutional effort, but I'm first looking at what the statutory point here is. What is the reason for this section?
So
and if I look only at the text and it says public, I think that means to tell the public.
and what the government said, and we don't disagree with.
What do you think is the answer to this question?
Oh, I think absolutely I agree with the government, is that it allows me to comparison shop. If I see $10 billion for colonoscopy and I see $1 million for colonoscopy, I'm going to go to the 1 million.
Okay, so it is
So
information. It is information to the consumer. I thought you, the reason I broke in was you were telling me that it's not information for the consumer. The statute is intended for the consumer. Is that right?
So the statute is intended for the public, which would include the consumers. Let me be very clear on this. The hospitals, what I'm saying with the statute is completely directed at is only information the hospitals themselves can disclose, which the hospitals can't disclose out-of-pocket costs. That is a very minor point. So it gets at the point that no one actually pays. And our point is that the statute can't be directed at what people pay because the hospitals will never know that. They don't even know what insurance companies will actually pay, which the government concedes, because the actual payment at the end of the day is going to turn on variables about patient care.
All right, I understand now. I got it.
So in terms of a First Amendment analysis, it is perfectly appropriate for me to stand up here and read to you what the government has said across 2 administrations, which is a good purpose for the disclosure of the charge master, that it serves a public purpose. And I not only personally agree with it, the hospitals agree with it, but it's a fair point as a First Amendment matter and as a textual matter that no one has disputed that gross charges absolutely means, standard charges absolutely includes gross charges. And that's also in the final rule.
Okay,
So,
I got it.
Okay.
Thank you. I appreciate it.
The one thing though,
I just,
sure.
Ms. Blatt, I just have, well, did you have one more thing to say in response to Judge Garland before I ask you an unrelated question?
Let's go with unrelated, but I do think though that I do think that this just segues into the 2 list problem, but let's go with where you are.
Well, no, why don't we talk about the 2 lists since you want to talk about that? And I just have a factual question for you, just a fact question, which is, is there's 2 lists, right? There's this shoppable services list and the comprehensive machine readable list, right? Those are the 2 lists. And you say the statute says a list can't be 2. This is just a fact question. Is there anything on the shoppable services list that isn't on the comprehensive machine readable list? In other words, is a shoppable list just a subset of the comprehensive machine readable list?
So it is a subset in the sense that I'm going to answer in the same sentence that a sentence is a subset of the alphabet and a recipe is a subset of a grocery list. So you have.
Well, how about, can we put it in terms of, is it a subset in the same way that an airline's rates for that coach is a subset for an airline offering service from Washington to San Francisco? Is they have 3 or 4 different rates. Coach is a subset of those rates, correct? Is that the same as this?
Yes, but if I could just answer the question, this list would say this is a customized thing that the travel agency does that throws in your hotels, your cars, and maybe some Disney Worlds and trips to look at SeaWorld. So what's the shoppable? So the machine readable spreadsheet is a raw data dump. It's just a raw data dump in Excel. It's very critical to understand that it's not just you take 300 items and move them over. You have to use judgment, and it would the different. Let me just here to get this out. It's different formats with different information to different audiences for different purposes. The different information, which is I think your question goes to, is that vaginal delivery or a sleep study or some very complicated things with or without comorbidity may not be the way it's described on the shoppable service list doesn't necessarily transform into a straight raw data. Now it might, because a straightforward thing like psychotherapy may have, a machine readable counterpart. But the critical part is once you get to the shoppable service list, which is this consumer friendly, and every hospital on its own, minus the 70, gets to pick any shoppable services that you would dream up ahead of time that you might schedule in advance. So it's like, oh, well, let me think about how I might need hospital care. And that's not the way the items and services in the DRG list works. So in that sense, I think a sentence, making a word out of the alphabet or using a recipe, because you have the ingredients on your grocery list, but somebody with some intelligence has to figure out how to put all those ingredients together. And there's no limit on how you describe your shoppable service. You can describe, I think the government had 17 references to ancillary services with stuff I'd never heard of. And it said, mix and match, it's not exhaustive. Just do what you think might be helpful for consumers. And so I think in the government's view that's just two lists. It has to be, because there's really no other meaning for two lists. Now, so I think that's my best answer for you on, is the information a subset?
All right. I have a question about your, I guess it's both your APA and your First Amendment. On page 43 of your brief, you say that the agency failed to grapple with the reliance interests engendered by its previous rules. What are those reliance interests?
Yeah, and I hope to make this as part of an Encino argument, but the reliance interest, I think, is
What is
in
it?
terms of, just let me put it in the box of First Amendment, because it's a better APA argument than the First Amendment. The First Amendment is grounded in much better arguments than the reliance interest. So on the reliance interest as an APA matter, it is that from the get-go, hospitals thought, actually the hospitals were just getting together their charge masters. And in terms of that, everyone agrees, the hospitals are wholeheartedly behind transparency, that they invested on a lot of time, money, and expense in two ways of getting this information to consumers. One is the price calculator tool. That's the alternative way of complying with the shoppable service list. So that helps. It's much more directly related to the problem. They sit down with you and you input your data, and it tries to give you, based on your plan, the information. And the second, which I think you might have had, is that one-on-one counseling sessions where they sit down with you and say, what's your insurance? Here's how it's going to work. What's your deductible? They try to figure it out. Now, and that is an investment. So this is a new regime, and we can talk. This is where the government really messed up. The government's rule prolifically says this is just no big whoop. This information is readily available on your rate sheets, and you're already doing it for states. So just put that information out there. You only need 30 days, maybe 60 days to do it. It only costs you $1,000. Okay, that was preposterous. So what the government in its final rule raised that to 11,000, and the government will tell you they based it on a hospital's organization, which the rule cites. The rule cites that hospital organization's estimate. But then the rule prolifically doubles down on, to justify the amount, that this information was at your fingertips and you're already doing it under states. Now, those are manifestly false, and the government's never contested it. And here's why. No statute requires this kind of disclosure. They're all based on retrospective data information where you then know the rates and then you can sort of calculate it. And the second thing is hospital after.
All new regulations, many new regulations require substantial additional investment by regulated parties. And here, the government seems to have been aware of that. Maybe not as much as you thought, but it did increase dramatically the amount that it thought complying would cost, and it extended it for a year. And it excluded hospitals that already have a tool that works. So what did it do that it should have done?
So there's a couple of misassumptions there. The machine readable spreadsheet is an absolute requirement. Therein lies the Herculean burden of negotiated rates, which don't exist in many instances at all on a knowable number. Second, many of them exist not itemized. So there is no way to put any information in that spreadsheet. Third of all, and so that gets to workability, there's still a burden problem, because even if there's a knowable rate, there's an actual itemized rate, Hospitals don't have the information. They have to manually reverse engineer it with clinicians, legal staff, and pouring through contracts and trying to figure out how this would work for up to 6,000 different permutations. So to say that they upped the number, but then I counted 7 times that they mistakenly said, you're allowed to burden someone, but heaven help that the APA at least requires the agency to at least understand the burden. I thought that they had to at least explain it and acknowledge it, but they misacknowledged it 7 times. They seven times said it.
Ms. Blatt, unless you're way over your time, conceitedly, we were the ones that took you way over it. But unless either of my colleagues have questions at this point.
Just one
Judge
thing,
Edward.
Judge Tatel. I've been listening carefully. Ms. Blatt, as I'm hearing your argument, you seem to be saying something that would cause me to conclude that neither the charge master rate, which you prefer, nor the government's present scheme is transparent. They're equally bad in terms of what they communicate. So I can be very honest with you in saying I'm not buying your argument to the extent that you're making it, that the charge master rate is discernibly more transparent than what the government is proposing. And especially when you say it's nothing more than a maximum, because in my mind, that means the hospital can tack any rate on the charge master rate because it's only a maximum. And we go down maybe, but you can say anything. I don't know how that serves the consumer. You're saying, well, the alternative approach doesn't either. But if I'm hearing you correctly, your principal objection has nothing to do with worrying about transparency. It's just that the government's approach is more burdensome on you and more expensive.
No.
Neither one is transparent.
Hospitals don't like lying to their patients, and this rule requires.
But you're lying to the patients, as I listened to your argument, in suggesting that the charge master rate is a rate. It's not. And there's nothing that says, as I understand it, you can tell me if I'm wrong, that alerts the consumer when they see that charge master rate that beware, because any and everything below this is possible. We do not want to suggest to you that this is the rate. Is that what you do?
So yes, in the sense of the hospitals have done the 2 things I've talked about, and states have done a lot in this respect at the initiatives of hospitals. And that is the price transparency tools that have been developed, hospital by hospital and state by state. But the answer to your question, if both regimes aren't so hot, is a vacature of the rule, because the agency, it's not just.
No, I understand. I'm just trying to understand what you're arguing, because the charge master rate, as you prefer, it certainly doesn't sound like a transparent approach.
So all I can say on that, again, and it is perfectly reasonable to take the government at its word that it may not be a perfect regime, but that Congress rationally wanted this information out because the government concluded it would bring down patient care and cause price competition. Now, if you don't buy the government's rationale because in 2019, they thought that didn't go far enough, that's totally fair and that's totally rational. But the statute didn't allow them to go this far. And with the 3 problems I talked about under the APA is that the workability problem, that it forces a misleading statement and then it compels corrective speech to correct the speech you didn't want to make in the first place. And then third is just the burden problem. But the big problem is the workability problem. Whatever answer we're going to hear when she gets up is going to be new to me.
Okay.
Thank you.
Okay.
Thank you.
Thank you. We'll hear from the government and I'll give you a couple minutes for rebuttal. Okay.
I apologize. Good morning. May it please the court. Courtney Dixon for the secretary. It's an unavoidable reality of the market for hospital care that hospitals have established different charges for the same items and services, which they will usually and customarily apply depending on the category of paying patient. The agency here looked at the realities of the market for hospital care. It looked at the statutory text, including the diagnosis-related groups clause, and it looked at the problem Congress was seeking to solve in the statute, specifically bringing down the cost of healthcare coverage. And from all of that, Your Honor, the agency interpreted standard charges to require hospitals to disclose 3 types of standard charges. There are gross charges, which are the usual or customary price that might apply to self-pay patients. There are any standardized cash discount prices, if the hospital has it, which is the price that the hospital would offer to any cash paying patient, regardless of insurance status, and then their payer specific negotiated rates, the rates that they've specifically contractually agreed with insurance companies to pay those insurance companies' beneficiaries and similarly situated persons, anyone with that particular insurance provider and likely particular plan. If I have Blue Cross Blue Shield and I go to a hospital, the charges that will usually apply to me have been set in advance. They're contractually negotiated. And it's ignoring the realities of the market for hospital care, Your Honor, to say that in that circumstance, the hospital is going to demand its charge master price. It's going to demand, again, the price that it's negotiated with the insurer. And under the current status quo, it's not that these charges don't exist. They exist. They're driving insured patients out of pocket expenses. The patients don't learn of them prior to care. They learn of them when they receive an explanation of benefits forms, weeks or months after the fact. At that point, the explanation of benefits form will say, this is what the insurance company, has negotiated and taken off. Their agency's rule, Your Honor, requires hospitals to disclose that information up front. And it concluded, based on the record before it, that consumers are going to benefit as a result. They're going to be motivated to use this information. I mean, the evidence in the record shows, Your Honor, that consumers currently are casting about for rate information and are so desperate for that information that they've taken it upon themselves to crowdsource the information that they find on their explanation of benefits forms, manually put them onto websites, and hopefully get some glimmer into these payer-specific negotiated rates that, again, under the rule, hospitals will have to disclose up front. I'm happy to address any of the...
But the payer, for someone, I want to make sure I understand it. So if I need to go to the hospital to get my appendix taken out, and say I have Blue Cross, the disclosure of the negotiated rates will help me compare hospitals in terms of what my out-of-pocket costs will be. Is that right?
It depends, I think, Your Honor, on particular insurance arrangements. So
because
yes.
Do I care?
Yeah.
Right? So
yes.
if I have to have my appendix out, I'll go see I'll look on this thing and I'll see, okay, my out-of-pocket expenses at Sibley Hospital are less than at Georgetown, so I'll go there. Is that how this works?
I think Your Honor's maybe example of an appendectomy might be perhaps the wrong example, given that an appendectomy we don't normally think of as something that's shoppable. That might require, an immediate hospital visit.
I see. Well, take for example, give me an example of one that. You mean like, say, a colonoscopy?
Yes,
right?
Sure. That's the example that our brief uses and that the agency refers to. Yes.
Yeah. Right. But that's what I'll be looking for, right? I'll be comparing what it costs me out of pocket at Georgetown versus Sibley, correct?
Yes, Your Honor. And if you have Blue Cross Blue Shield, a particular plan under the agency's rule, you could look at Hospital A, Hospital B, look at the payer-specific negotiated rates for your provider and plan. And if you have a high deductible health plan, the payer-specific negotiated rate that listed, if you haven't met your deductible, may very well be your out-of-pocket expense because you'll likely bear the full financial responsibility without any cost sharing. If you have an insurance arrangement where you have a cost sharing arrangement with your insurer, say the insurer pays 80% and you pay 20%, if you look up the payer-specific rates, you're going to have to do some math applying your insurance plan. So you might have to take 20% of the payer-specific rates. It might not be, a perfect estimate of out-of-pocket expenses, but under the rule, you have a far better estimate of your out-of-pocket expenses than currently exists. And in which, if you tried to look up Hospital A and Hospital B, you're going to see charge master rates, which likely bear little to no resemblance to what you will actually pay. And of course, under the agency's rule, you could compare payer-specific negotiated rates with any potential standardized cash discount prices and can determine whether it's cheaper to pay for your care directly in cash rather than go through your insurance at all. And plaintiffs have suggested, Your Honor, that if a hospital doesn't have a standardized cash discount rate, which under the agency's rule means that it applies across the board to any patient, regardless of insurance status, as I noted earlier, who is going to pay for their care in cash. If a hospital hasn't established such a standardized cash discount price, it would report its charge master price. And that's not misleading because, of course, if you say, I want to pay for my care in cash and there's no standardized cash discount price, the gross charge or the charge master charge is the price the hospital would presumably come back with. Now, the idea that that disclosure of that rate would mean that someone would think there isn't individualized cash discount rates. I mean, I have two responses. First, of course, under the disclosure of just charge master rates, there's no indication of cash prices at all. And so it's unclear how that is any less misleading to consumers than saying a standardized cash discount price. At a minimum, under the rule, you could see a standardized cash discount price and know that cash discounts are a thing. Again, under the current status quo, patients are in the dark about these things prior to care. I'll also note, and the agency has remarked throughout its rulemaking, that nothing in its rule prevents hospitals from providing additional information to consumers. The agency has lauded such efforts on behalf of hospitals. Hospitals are free to remark on their websites, to remark in patient interactions, to say, you know, we don't have a standardized cash discount, but we offer individualized cash discounts in certain circumstances, or we offer sliding scale cash discounts. Nothing prevents hospitals from doing that. And again, at a minimum, under the rule, consumers might know to ask those questions, and they don't currently know that under the current regime. So again, based on the record before the agency reasonably concluded that this rule was going to meaningfully benefit consumers. The agency acknowledged that there are a lot of potential barriers that currently exist to allowing patients to perfectly shop for care in all circumstances. Some of those are inherent in hospital care itself. Your Honor mentioned appendectomies. Shopping for appendectomies might not ultimately be a thing. Hospital charges are also inherently complex. And some consumers might not be able to perfectly estimate their out-of-pocket expenses in all circumstances. The agency acknowledged this, but it nonetheless reasonably concluded that its rule was a necessary first step to bridge the significant gap that exists between consumers and hospital costs, Your Honor, in which, again, the record was very clear that consumers overwhelmingly desired the type of information that the rule requires hospitals to disclose, and that currently consumers are incredibly frustrated. I mean, the hospitals have noted, of course, sorry, Judge Tatel.
No, you finish your sentence and then I'll ask you a question.
I was only going to remark briefly that the hospitals have noted their current efforts at one-on-one counseling or offering other services. I mean, again, the agency lauded such voluntary efforts, but the evidence in the record before the agency was clear that consumers don't think that the current status quo is working for them. And of course, hospital charges are not going down, or at least certainly not as much as they could or should. And so the agency made accommodations to hospitals who are offering price transparency calculators already. They said you don't have to satisfy this shoppable services list, which is trying to serve the same goals. But it's certainly, Your Honor, not an answer to say that, well, some hospitals are doing this voluntarily, because again, the evidence before the agency was quite clear that consumers are very frustrated about the current status quo.
And so what's your response to Ms. Blatt's argument about a list? She says the statute says a list, that means one list. This requires two lists. And she says in response to my question that it's just not true. It's just not accurate to say, as you do in your brief, that the shoppable list is just, I think you say in your brief, nearly another way of describing or portraying the data on the comprehensive machine readable list. What's your answer to that?
Right. So under the rule, hospitals have to establish a list of their items and services, standard charges for items and services. That's reflected in the comprehensive machine readable file, which puts all of the charge information in one place. Again, it's comprehensive for all of the hospital's items and services. There's a separate display of charges for 300 shoppable services. The statute gives the secretary explicit discretion to specify how hospitals are to make public their list of standard charges. There was a question, Your Honor, about differences between the shoppable services list and the comprehensive machine readable file. All of the standard—
Right, is everything, pardon me, say that again, I'm sorry.
I think I was gonna perhaps anticipate your next question, which
Go
is
ahead.
Whether there's a difference, right? So all of the standard charge information that will appear in the shoppable services list is derived from the comprehensive machine readable file. Differences are that in the shoppable services list, there has to be a plain language description of the item or service. So in the comprehensive machine readable file, you can imagine, a more complicated hospital jargon versus in the shoppable services list, it's intended to be more consumer interfacing. There's also some differences in how the information has to be organized and presented, because it needs to be organized by shoppable service and then including any ancillary services. So for example, To use the colonoscopy example, the hospital will report a price for colonoscopy, and then maybe in providing colonoscopy, the hospital also charges a facility fee. So the hospital would list facility fee along with colonoscopy. Maybe the facility fee charge is already included in the colonoscopy charge, so the hospital could note this is included. Maybe it's an additional fee in which they would provide the number of the fee or the amount of the fee. But the charge information there, Your Honor, is going to be the same information coming from the comprehensive list. It's just hospitals have to organize it in a more consumer-friendly way and, again, use plain language. All of which, again, is consistent with the Secretary's explicit statutory discretion to specify how hospitals are to make their standard charges public. And yes, the agency gave hospitals fairly wide discretion in how they organize their shoppable services and how they list ancillary services. And that's because the agency recognized that hospitals have a variety of ways of offering their services, grouping them together. Not all hospitals are going to charge the same kind of fees along with the service as others. So there's going to be differences here. But even knowing that those differences, looking up hospital A, looking up hospital B, seeing that there are different ancillary services for a single procedure, that's providing information to the consumer. Because again, all of this stuff is still driving consumers out of pocket costs. Consumers just don't learn about it prior to care. And the agency has decided in this rule that, sunshine is the best medicine. And that, again, as the record evidence suggests, consumers are going to be motivated to use it and they'll benefit as a result.
Could I ask you about the burden argument that opposing counsel made, which I take to be an arbitrary and capricious argument under the APA? So it seems like, looking at their brief at area 52, 53, it seems like their argument is thousands of different negotiated rates and non-straightforward clients, and that the hospitals calculate rate data by patient, so they can't even readily identify the rates that you're asking about. And maybe a last argument that it's all based on algorithms, which you'd have to reverse engineer in order that they would have to reverse engineer in order to determine. And so as a consequence, one, I'm trying to remember what the words that were used. There was two P's, pernicious and another P. And then the second, two adjectives describing it, and then the second one being that it costs way more than the government calculated.
Right. So I guess there's a few things to unpack there, and starting maybe with the cost argument. The hospital's estimate of 150 hours per hospital, or approximately $11,000 to $12,000. 150 hours was also the same burden estimate reached by plaintiff's own amicus, the Healthcare Financial Management Association. Is
there a dispute about whether that's every year or just the first year?
The Healthcare Financial Management Association says in their amicus brief that they meant that only for the first year, and they meant that to continue for subsequent years, versus the agency concluded, I believe, that in the second year and onwards, it would be maybe $4,000, $3,000 lower. But the agency's conclusion there is reasonable because, a lot of the burden estimate that hospitals are talking about here is the burden of compiling this information in the first instance. It's reasonable to conclude that once they've done so and they've built the infrastructure, they've got the system on, they've got the list online, that the burden's only going to diminish in subsequent years. And again, the fact that the agency reached the same first-year burden estimate as the Healthcare Financial Management Association belies in the assertion that the agency was off here by orders of magnitude. And of course, the agency increased its burden estimate quite significantly from its proposed rule. The hospital's comments about burdens did not fall on deaf ears. Again, the agency delayed the effective date of its rule by a year. It increased its estimate and it provided accommodations. If you've got a consumer-facing price estimator tool, you don't have to compile the separate 300 shoppable services list. The point of that display is to allow consumers to, better engage with this pricing information in a consumer-facing manner. A price estimator tool is going to serve the same purposes. And so the agency recognized, hey, if you've invested your time and resources in that, it's getting at the same thing our rule is. You don't have to comply with this separate list. So yes, the hospital's burden estimates weren't falling on deaf ears. The agency accounted for them, and the agency came to a reasonable conclusion about that estimate. The agency, of course, parted ways with the hospital in the sense that the agency believes that the benefits of this rule outweigh those burdens. But the point of this rule, Your Honor, is to attempt to shift some of the frustration that consumers currently face. In that,
okay, what about the second part of the argument that they really can't even do this, that they calculate things by patient, they can't identify the different rate groupings, that they ordinarily build algorithms that cross-reference each other, and so they can't really translate this into the kind of formula that you want?
well, I think maybe there's also some misunderstandings about what does need to be disclosed under the rule. As we explained in our brief, if a hospital has negotiated with one insurer on a per X-ray basis, then a column in the item and services list would be per X-ray, and then you would note, I've negotiated with Anthem $500 per X-ray. If you haven't negotiated with other insurers per X-ray, you would put not applicable in the other columns. That's in the rule, that charges have to be reported as applicable. If you've instead negotiated with another insurer on just a procedure basis for, say, the whole colonoscopy itself, then you would say, I've negotiated with Anthem $15,000 for a colonoscopy, and you would say, and you wouldn't need to necessarily separately say, sorry, I'm trying to describe this in a clear manner, in that it's not that the hospital needs to reverse engineer from that colonoscopy package what a specific X-ray might cost in that package. If it's negotiated per package, then you report the negotiated rate for the service package. If you haven't negotiated a specific per X-ray price with that insurer, you don't have to report it. And so it's hard to talk about this in the abstract. The agency has, of course, put out guidance recently that it has some examples and charts along the same lines as I'm describing. And I apologize if I'm, if in any ways, mucking this up. But I just want to be clear that if a hospital hasn't negotiated a specific price for a specific item with a specific insurer, they don't have to try and reverse engineer what could a price be for that. They would say not applicable in that circumstance, and they would report the package as they have negotiated it with the insurer. And to the extent that hospitals might have to, manually scour contracts or engage in other kinds of, compiling efforts between how they do their billing systems, again, a part of this rule is that's a feature and not a bug, in that these rates exist, they're contractually negotiated, they drive patients' expenses, and they're reported after the fact in explanations of benefits forms. And so it's not that, under the current status quo, it's not that not reporting these algorithms, they all go away. Consumers bear them, they're frustrated about them. Under the rule, if hospitals have to sort through their billing requirements, spend $12,000 up to sort them out for a year, then that's a benefit of the rule, and the agency reasonably concluded that benefit serves the statute's goals. It's going to benefit consumers, and it outweighs the burden on hospitals, which again is going to diminish over time after this has been done in the first instance.
Thank you.
Judge Edwards, Judge Garland, any further questions?
Oh,
okay. Okay, thank you. Ms. Blatt, you can have 2 minutes.
Over.
Other way.
Aaron, come on.
There you go.
Center me, please, and raise it. Okay, good. Can you center me a little so I'm not?
This is very sensitive.
Okay, well, I can just lean down. Okay. I'll take off my shoes.
Would you like it up, down? Or?
No, we're good. I just took off my shoes. Okay, thank you. I'm going to go backwards because I'm going to start where we left off. So there are 2 separate problems. The workability problem is separate from the burden problem. And I told you I would hear for the first time what her answer to the workability problem was, and I have to say I didn't understand it. The workability problem is this, and the cites are in page 9 to 10 and 20 and opening brief, page 24 and 26, and the hospital's brief are the avalanche of comment cites that dictate this in toto. You will look for the rule, and the rule will be silent on 2 problems that have nothing to do with burden. They are incompatible. The rule, you cannot comply with it in the way the government thinks is possible to communicate any relevant information. On the algorithm, Judge Garland, that is not a burden problem. The rate exists, you just don't know it until the patient showed up for care. It could be on a volume discount. If you come in for one x-ray.
I understood that. That's why I asked it as two separate questions. One, how much the whole thing's going to cost, and two, whether it's doable at all.
It's not doable at all.
But I know, but she did answer both parts. Now, I take your point to be that she's answering something that you didn't hear before, but other than that.
And that she still hasn't told, I still could not tell you how a hospital, she just says hospitals don't report it, I think, even though an x-ray seems to be a problem. And it doesn't even matter what she says. The agency did not speak to this at all. The second thing the agency didn't speak to at all is the problem with the bundled rates. And again, those rates, those things are allowed and they're knowable in advance. They just don't exist in the machine spreadable way. And she's just wrong. The rule requires a number. You don't get to put explanations. You don't get to put bundled. You put a number. And the guidance,
or you can put NA, right?
Or you can put NA, which means to me that is not a service offered. The burden.
Well, that's not. Well, that may mean that to you, but I understand her point to be that means you don't have the number available. Not that the service isn't offered, not that you don't do x-rays, but that you don't have a negotiated charge or a cash charge or something like that for it.
And that's fair if the agency wants to explain that, which they didn't. I don't think you get to make it up on your own.
I understood that perfectly from the beginning. So that's what the words not available normally means, that the answer is not available, not the service. You think somebody would think if you put NA next to x-ray, that means your hospital doesn't do x-rays?
Yeah, remember, this is in a 500 million or 250 million data entries.
Okay.
But so on the burden point, the burden is for rates that do exist. There's a number out there. The problem is you have to reverse engineer it. This has nothing to do with the algorithms or the bundle. It's just to comply with the rule, you have to reverse it. And that, because
Ms. Black, give us an example. Just instead of talking generalities about reverse, just give us an example so we can understand it. What do you mean?
Yeah, sure. So hospital billing works when the patient checks out, you call to adjudicate the claim. And so you enter all the data points, and that's the way the hospital billing system is set up. And the comments that I'm explaining go through this in excruciating detail. So they can plug in after the fact, plan A at inpatient this and location this produces this. But what the contract doesn't tell you is what that rate was to start with. And there's not a rate sheet, which the government kept saying in the rule, just look at the rate sheets. And the hospital said, I don't know what you're talking about. There aren't rate sheets. These are spelled out in contracts in text. And we would have to set up vendors, consult with legal staff, and insert with clinicians. And that's what the comment said. And the agency, this is why the rule is so fatal. Instead of responding, the agency said two misassumptions. In addition to, totally fair, we picked one of your amici, but 7 times they misstated, this is no big deal. They end with.
Can I ask, I'm sorry, let me just from my own experiences, because it's the only way I can understand this. So if I go to the hospital, particularly if you go to the emergency room where your Blue Cross Blue Shield doesn't cover everything, or maybe doesn't cover it all. At the end of the day, you get a list of charges from the hospital. You are charged X for your x-ray, you're charged Y for your visit, you're charged C for your lab test, and each particular kind of lab test, a different kind of charge. Then the next column says how much your insurance company paid for it. Now, are you saying that the first column, the charge for the x-ray, not how much the insurance covers for it, but the charge for the x-ray is not standard to people, say even Blue Cross patients? It's different for every single one, recalculated somehow?
So no, there's a couple points. That might be the rate applicable under that plan, but to go figure out what that amount was, it's not in a rate sheet. So you have to figure it out. The workability problem is
somebody had to figure it out after the fact.
Yes,
right?
And that's the way.
And I'm asking you, did they figure out after the fact because of something about me, so that if Judge Tatel went and got the exact same test under the exact same Blue Cross Blue Shield plan, he would get a different charge?
He might get a different charge because, I mean, well, there's so many. So this is why the comments do it. His severity is different. If his
I'm asking about things like a lab test for X, I don't know, for coronavirus, for example, a lab just to take an example, which fortunately is not applied to me.
Yeah, lab test is a good one.
Okay, or a standard X-ray of whether you have a broken leg or not. Judge Tatel and I would not get a different column saying charge, would it? I get a bill from the hospital. It says charge. It lists on the left. It says X-ray. Next column it says charge. Next column was how much the insurance company paid.
Same plan, same inpatient, outpatient, same location, you might. And here's why that doesn't solve any of the problems.
Same location being the same hospital, which is what's at issue.
Right. And I think this goes to Judge Edwards' claim about, well, what are we supposed to do with
not making a claim. Let me just be clear.
Okay. Well, Judge Edwards raises a good point about what do I do if I don't like what anyone says. What the statute would have allowed is what states are doing with this problem. It's not like this is some new mystery. What states have asked for, because it's not doable, what the government wants is after the fact adjudicated claims, put that in a database.
Why isn't this what I just described? Even for the small universe that I'm describing, why is that not doable? Why is it only after Judge Garland leaves the hospital that they know how much to put on Judge Garland's
for the two reasons.
X-ray charge?
For two reasons. The X-ray charge might be billed on a per diem or per item, or it might be billed on volume discount, and you don't know that in advance. So it's only when Judge Tatel, it just so happens that both of you had the same care. But in advance, I can't tell you what the X-ray price is. And the statute requires itemized, and it's an unknowable number. The second problem is—
I still don't understand that, Ms. Vi. I don't understand what you just said.
Sure.
Why is the price of the X-ray unknowable?
Okay, and this is, again, it would have helped had the agency addressed it, but what the hospital—
Why don't you just explain it? Sure. Why don't you just explain it to us?
Okay, so
about why it's unknowable.
So the volume discount, I think, is the easiest. If Judge Garland, because he presented a different scenario, got 2 X-rays, it's one price, but Judge Tatel only needed 1 X-ray.
Now, let's say we both only want 1 X-ray.
No, but that's what I'm saying. If you both got the same care, you would know the amount after the fact, but you didn't know the amount before the fact because no one treated you.
Well, wait a minute.
Sorry.
We would know.
But no, it's just an X-ray.
Because
just an X-ray.
Sure. The spreadsheet.
It's just an X-ray.
The spreadsheet requires you to put in a price for an X-ray. Well, I don't know it yet because if Judge Garland needs 2 X-rays, it's going to be $50 total.
No, but if we each need 1 X-ray, just one, the price of an X-ray is $100.
Should be the same price.
If I have 1, I'll get charged for $100, and if he has 2, he'll get $200, right? Or more likely $5,000 and $10,000.
So right? I think the problem is that you guys have figured out maybe a way, if the government wants to try to explain this in the final rule, that what you're talking about is what the rule wanted, but the rule is silent on this. That the rule assumes that because we're not looking at after the fact, patient care is irrelevant. But what the hospital said is that their rate negotiation is not just a volume discount, but it might be billed, if it's billed per diem or per item, what are you supposed to put? It's a legitimate question that the hospital hasn't answered. Now, they did answer the question in the government's brief about if there's just an N applicable. And Judge Garland, you and I can disagree on the misleading, but misleading aside, the government has to explain how this rule is workable, has to acknowledge the problem, and then say, okay, I hear you, but here's the answer.
If you don't mind, since we're running low on time, I have another question. This is just, again, back on the text and the meaning of standard. So, and you were using the example of sticker prices on cars. If you had the same statute, but it was about standard car sale prices, would it be, if the government said you have to list your walk-in price, you have to list your preferred member price, namely like AAA or something gets a discount, and you have to list your corporate fleet price, or at least the corporate fleet price you pay to Ford. Would each of those be standard prices, or do you think there is no standard price in that circumstance? You can't have a subset of standard prices.
You could have a standard price that is what the 2018, which I mentioned to Judge Edwards, the median or average. That you could have a standard.
I'm not asking for the median or average. I'm asking, could you be required to list the price that you charge corporation, Ford, General Motors for their own fleets, I don't know, Hertz for its own fleet if it weren't bankrupt, The price that you charge AAA members who apparently, in the old days had some kind of discount at a car sales place. Would those
Right.
not be standard prices anymore?
So it's two answers. No, but no, because the statute didn't say. If they had asked what is your standard price for this particular location in this particular subdivision, fine. You'd still have a problem with the government says it's not an asking price, it's the amount that everybody settled on. So the government kind of went off a cliff because it's every price, any and all, and every individually negotiated.
Well, I'm just trying to just use my hypothetical.
Yeah, under your hypo, I thought I answered it.
It is a single location, just like it would be a single hospital. It is a single location. It's Don Bayer Volvo, which I've never been to in my life, but just as an example. Okay. Right. And they were required to put on the sticker how much they charge, what is their price for this car to a AAA member? What is their price for this car to a corporate fleet? And
yes.
Yes,
and I was trying to say yes. And so if the statute poses the question your way, what is the standard?
Not if it does it my way, if it does it exactly the way it is in this case.
So this adds the word in with respect to any subpopulation.
So you're saying that it's the because they're using subpopulations that cannot be a standard charge under the statute. Is that no matter even if it's easy, even if it's clear, all the rest of your arguments are just cherry on top. In fact, even if everything was perfect and it was easy and no burden, still wouldn't meet the statute.
Yeah, so there's two layers to the argument, and what I hear you putting pressure on is if you thought there was enough ambiguity that you could add subcategories of patients. And that's one way of looking at it. And I'm saying they're doing every single identified. The other problem that I still think we have this argument is that if they're right that everything specific is standard and charge is not limited.
I'm not saying everything specific. I'm saying I'm giving you three categories in a hypothetical in a car dealership. Would that fit as a instead of the word hospitals, a car dealer's standard charges?
For cars, you have to do one price. If it says cars for the way your hypo was for the walk-in versus then you could have a standard asking price for each subset.
And that would be okay under the statute, or the statute would have to be amended to include the word subsets?
Yes, but we were taking your hypo.
Yes means and
yes, it is adding words that aren't in there.
And therefore, it would not fit the statutory. It would be wrong under Chevron 1 or 2 or both.
I think it's definitely wrong under 2, because then you add in, they're asking for, or 1, they're asking for every. And it's one thing to say, well, we'll do it by, an insured rate. But if just your hypo is for every walk-in rate that's identified by a different person.
No. My question is, you go to this place and you're required, and the rule says for each car, it has to give the rate for a corporate, if you're asking as part of a corporate fleet, the rate if you're a AAA member, and the rate if you're unaffiliated. Now, is that not is that not an appropriate set of standard charges?
For a statute that just said, what are your standard charges for cars?
Yeah.
The answer is no. Now, I'm saying even if you don't like that answer, it's not what the government did, because the government is not the standard asking price for subsets. It's the actually agreed upon price.
Okay, I understand.
So that's all I was trying to say. Now,
Okay. All right. Anything else, Judge Garland?
No, thank you.
Judge Edward?
No, thanks.
What?
Thank you.
Okay.
Thank you.
Ms. Blatt, Ms. Dixon, thank you very much for your arguments. The case is submitted. The court will take a 10-minute recess.
This honorable court will now take a brief recess. Attorneys, J's, and law clerks, what this means is I'm putting you in the waiting room until we reconvene.
Merrick, don't turn it off. Don't turn yours off.
I'm not going to.
No, Merrick.
I wouldn't dream of
What do
it.
you mean turn it off? No way.
Don't. Just
I'm not going to.
No, don't.
Harry, can I go get my coffee?
Yes, you can.
If I leave it on?
Just don't turn anything off. Leave
Can
it.
I block the video?
Yeah, and then put it back on. Yes.
Yeah. Okay. Thank you.
I'm not going to even do that, Harry.
All right.
Ah.
Merrick, you're using a laptop, right?
I am. I'm using a court-issued laptop.
Okay.
Is that okay?
Yeah, nothing wrong. I'm just trying to figure out on the video ratios what's happening.
I was told not to use the,
High def.
no, not to use the iPad.
Right.
Oh, I'm using an iPad, Harry.
You're, as long as you're getting away with it.
Ms. Citrin, if you could please turn your video on.
Who?
Ms. Citrin, the attorney.
Okay.
Thank you. Perfect. Thank you. This honorable court is again in session. Case number 20-1003, Tri-County Telephone Association, Inc., petitioner versus Federal Communications Commission and United States of America. Mr. Adamchak for the petitioner, Ms. Citrin for the respondent.
May it please the court. My name is Keenan Adamchak, and I represent the petitioner in this case, Tri-County Telephone Association, Inc. I've informed the clerk that I have reserved 2 minutes for rebuttal. Your Honors, I'd also like to let you know this is my first time making an oral argument. I've served as second chair on several cases before this court, but it's my first time in the hot seat.
All right, we'll go easy on you then.
I'm sorry, sir.
We'll go easy on you.
Thank you, Your Honor. I appreciate it.
Well, he said that. I didn't.
Your Honors, this case primarily concerns whether the FCC is permitted to expand universal service support by hundreds of millions of dollars to purposes unintended by Congress. Furthermore, this case also concerns whether the FCC is permitted to make these changes without first seeking public input regarding the impact of these changes on carriers such as TCT, who are USF contributors. TCT's arguments consist primarily of 5 points. First being Section 254 of the Communications Act does not permit using universal service support for disaster relief efforts.
All right, can I ask a question about that?
Yes, Your Honor.
I want to be clear so that when the next disaster occurs, we know exactly what your position is. If a fire destroys all telecommunications in Wyoming and Montana, you can get nothing out of the Universal Service Fund to replace it or to repair it on emergency or other basis. Is that the position?
No, Your Honor. According to Section 254, there's nothing explicitly states that universal service can be used for disaster relief.
So the position is that you could not get any money if there's a disaster in your area.
Yes, Your Honor.
Okay.
The reason for this is, one, Congress did not explicitly state disaster relief is a universal service principle. Also, the fact that it was stage 1 funding and stage 2 funding, it's apparent that they were using high cost support funding for disaster relief efforts, which according to Section 254(b)(3 relates specifically to ensuring both reasonable services and reasonable rates.
Why does it doesn't have the word both in it, but it says should have access to telecommunications and information services that are reasonably comparable and that are available at rates that are reasonably comparable. But if you don't have any service at all, then you don't have access to services. I'm not sure what reading could mean that providing access, if otherwise you get no access, isn't covered by 3.
Your Honor, 3 says you need the crucial word there is and, which distinguishes services and which says services and rates are part and parcel of the same thing.
Well, but you don't get any rates if you don't get any services at all. So if you don't have access at all, the statute provides, including low-income consumers and those in rural, insular, and high-cost areas should have access to telecommunications and information services, including, that are reasonable compared to those services provided and that are available at rates that are reasonable and comparable. So it has to be both comparable and rates. So if Puerto Rico has no access and Wyoming does have access, that's not comparable, is it?
No, it is not, Your Honor. But in order to make sure that you're ensuring comparable services or access, you must also be considering whether or not those services are being offered at comparable rates.
Isn't the first question whether you get services at all?
Yes, Your Honor, but as soon as you consider whether or not they get services, you also got to make sure under B3 whether or not they're also getting comparable rates. As the court said, as the 10th Circuit said in Quest 1, when they looked at this, they said consideration of rates cannot be divorced from consideration of
That's under certain extreme circumstances they were talking about in Quest 1, right?
They were talking about in Quest 1 whether or not specifically the definition of universal service rates.
That was when they were talking about you have to consider rates. That was under certain extreme circumstances where subsidization would be so large that it would destroy the whole program. They weren't just talking about rates, period.
Yes, correct, Your Honor. They were also talking about the need to balance different factors of 254B with one another, and
Right.
as to whether or not rates would be so large would trigger the B5 requirement of predictability and sufficiency of the fund. And here, if they use universal service support for natural disasters, if it happens again, and if it happens again, and it happens again, you know, these are billion-dollar catastrophes affecting citizens of the United States. And you know, in the long term, it's just we're going to require a lot of funding, and over the long term, there's no predictability of what the next disaster costs. You know, how much money is going to need to go to this, and the fact that more money will need to go to this by the sheer nature of these extents of the damages of these hurricanes.
Where do you get all that from the statute? Where do you get all that from the statute? Tell me what in the statute supports your conclusion about disasters. What language in the statute does that? It says, as Judge Garland pointed out, it says should have access to telecommunications and information services. Should have access to it. What in there says that they can't use the money to provide access to people who lose it because of a hurricane?
Because B3 focuses on access at reasonable comparable services and rates. It doesn't specifically say anything about people losing the service because loss of service because of a natural disaster. There's nothing in the language there that says that.
Suppose the people in Wyoming lose their service because their local phone company goes bankrupt.
Yes.
Well, suppose instead of Puerto Rico having a hurricane, they had lost their service because the telephone company in Puerto Rico went bankrupt.
Then another carrier would have to step in and become a carrier of last resort to offer service.
Wait, but suppose there isn't one, and the Universal and the FCC decided they need to provide additional funding to provide an incentive for the new company to come in. They can't do that?
I believe they could do that to offer to ensure access, but they must also be ensuring access at services and rates. See, the problem here is disaster relief constitutes a whole separate level of funding, a new support mechanism altogether. And that
why?
Because using disaster relief is basically the restoration of services. It's not ensuring that services are there and continue to be there to high cost areas, because high cost means that these areas cost more than the average cost of services cost the country to provide service. And so high cost provides compensates carriers for the difference between the cost of providing service and the actual rates in service. Disaster relief is something, it is so broad, and Congress would have specifically considered it as a separate funding mechanism. It's so distinct from just making sure that there are services available to areas where it's very expensive to provide service. And that would trigger 254B7, where the FCC would have to have worked with a federal state joint board and universal service to come up as funding disaster relief as a principle of universal service. That goes into my next point about the joint board. The FCC here failed to refer the matter to the joint board about whether or not universal service support can be used for disaster relief funding. There's nothing specific in the statute that says the FCC can act unilaterally to expand universal service to disaster relief.
So that argument only works if we don't agree that the principles of 1 through 6 apply, right?
Correct, Your Honor.
So if we read the statute, particularly section 3, as including the consequences of disaster, then your argument about joint board, there is no argument about the joint board then, right?
That is correct, Your Honor. The only way there would be an argument there would be if you considered funding for disaster relief to be so broad that it doesn't fall into those categories, like you said. So here, 254 does not specifically say the FCC can act unilaterally to implement universal service support. As I was saying, they have to go through the receiver recommendation from the joint board, and then the statute specifically says the FCC will consider and assess what the joint board's recommendations are.
Tell me again, what provision in the statute you think bars use of the universal service in situations involving disaster relief?
254B3, which states that high cost support is supposed to be used to ensure reasonable services and reasonably comparable rates. And also, it does not comport with the sufficiency and predictability principle under 254B5. Natural disasters, by their very nature, are so broad and unpredictable that it requires such an increase in funding to continue to support these disaster reliefs over the long term. This became $1 billion program. Hurricane Katrina in the past, cost millions and millions, if not billions of dollars in overall damage. So those are B3 and B5 is where it does not comport. And since it's a whole new mechanism, it would have to been created under B7 in conjunction with the joint board. To turn to my third point, the FCC also failed here to show good cause for for suspending notice and comment prior to issuing the stage 1 support. They argued that the annual hurricane season was a sufficiently imminent and real emergency to justify the suspension of public input before issuing another $64 million in relief to the islands. In a sense, the FCC created their own problem here. They issued.
You don't think the hurricane created the problem?
Your Honor, yes, the hurricane did create the problem, but they waited 8 months after Hurricane Maria.
Well, they concluded two things there. One is that access had not yet been reestablished. And second, another hurricane season was coming.
Yes.
To see how much greater of an emergency there ever would be.
And it needs to be a concrete emergency, Your Honor. It needs to be on the doorstep. But this will happen.
You have to wait until there's a hurricane warning coming? Is that what you're saying?
Yes, Your Honor. I believe it needs to be sufficiently imminent. There needs to be a clear and concrete emergency. Hurricanes don't hit the islands every year. You
have to wait until either the Weather Service knows for sure that it's going to hit Puerto Rico, or wait until after it hits and the disaster occurs. In a circumstance where they are already not having full access because of the last hurricane, and they still don't have full electrical power or anything else.
Yes, Your Honor. If they're going to base it on a hurricane, they would need to point to some other sort of emergency altogether to suspend notice and comment.
Okay, thank you.
And they also tried to suspend notice and comment on the fact that if they didn't give the money right away, carriers were going to go out and use cheaper restoration efforts. There was nothing in the record that said that carriers were going to do this. In fact, the comments just said, the funding you gave us in the past was good, but we need more. We're using generators. It never said, hey, if you don't give us funding, we're going to find cheaper ways of doing this. It just said that it wasn't explicit.
In what situations do you think, if any, that funds can be used where an area has access and then it is lost, not because of a hurricane, it's just lost. And so they don't have access anymore, as B3 contemplates. Can funds ever be used there? I mean, it's kind of a variant on what Judge Garland was suggesting, because you clearly have no access if it's lost. Now you're focusing on it was a hurricane. Well, let's make it, tell me anything that would be permissible once the service is lost. In other words, they had access and now they don't. In whatever area you want to put it. Can funds ever be used?
Yes, Your Honor.
Give me an example, like when?
If the facilities in that area are too expensive to operate to ensure some kind of reasonably comparable level of service. And
No, you're just stating the statute. I want a situation. They had access that was fine, no issues, and then something happens. I want to know whether you think there can ever be this scenario where something happens and now they don't have that access and don't make it a hurricane. Is there any situation?
Yes, Your Honor. I believe there would be, when in the sense where it's become too expensive to operate in that area, and they need some kind of funding to bridge the gap between, the cost of the carrier to provide rate and the cost of the carrier and the cost of the rates, ensuring reasonable rates to the consumer.
Sorry about the dog. She only barks when she approves of what you're saying. Sorry.
Thank you, Your Honor.
Yeah.
But
if the disaster is a business who is holding effective control over access by the rates they charge or the services they offer, suddenly jacks everything way up. So you effectively have a disaster. So access is no longer any good. That's good enough?
Yes, Your Honor.
Whereas a hurricane, which comes in and essentially does the same thing, unexpected, except it's a hurricane, it's not a business charging new and higher exorbitant rates. That's not okay.
It's
and
not
in both
okay.
situations, there's a loss of access. I don't get that. I don't know how you get that out of the language.
It's because you have to read, and when the FCC implements 254B's principles, you have to read it as a whole and balance everything together. When you look,
all I'm trying to figure out is how you make the distinction you just made. So now I don't have access because the businesses, the people who apply services, business, they are now doing a number on us and we simply can't manage it. So we're in a distressed situation and we need help, as opposed to a situation where a hurricane comes in and does a disaster on us and we need help. And you say in the former situation, business related and real, and it's a true disaster, it's okay. But in a hurricane, it's not. I don't get it.
Because hurricanes are so unpredictable.
Well, the business pulling a number where suddenly all of these different parts, the supplies, furnishing services, et cetera, are no longer what they were, unexpected, but it's there now and there's no access. And you say that's okay, you can help them then.
Yes, I believe 254 contemplated the business arrangements of the cost of providing service, because businesses all of a sudden could not face the high cost of operations in these areas, but for federal aid. Hurricane relief and disaster relief is something on a whole nother level, a whole nother greater magnitude. This was focusing on allowing a business to operate in an area because it was too expensive to operate there. Disaster relief, by its sheer size and sheer unpredictability, takes it out of that ballpark, and it becomes a whole new species.
Oh, no, I mean, you're wanting to change my hypothetical. I'm trying to give you a situation where access was fine before, and something now happens other than a hurricane, and these people need help. And you're saying, no, hurricane's different than any other thing I can imagine.
What was your answer to Judge Tatel's question about bankruptcies?
If a carrier goes bankruptcy, another carrier would have to step in, a carrier of last resort. because there always has to be a carrier providing services to these areas.
Well, what if there, again, just to follow up, I'm still not Judge Tatel's second question. Imagine there's only one carrier. It's a rural area. There's only one carrier. Nobody else is willing to go without more money.
Or make it a supplier.
Do they get more money?
Or make it a supplier who no longer is willing to supply to the carrier.
If they're not able to, if they are not able to provide service, absent federal funding, then they need to get.
That's what happens when you have a hurricane. Just like either the carrier is gone, or the supplier of the carrier is gone, or the hurricane comes. You no longer can furnish the service. And we're struggling to try and understand how you're distinguishing one from the other.
The only way you can distinguish one from the other is one is has been contemplated by Congress. Businesses just the economics of it are not working in that area. For whatever reason, they can't service that area without support.
Well, Council Cohen, the economics are not working post-hurricane. That's why you need help.
You know, let me ask you something else. You know, you keep emphasizing hurricanes are unpredictable, and you answered in response to, I think, Judge Edwards, you said they would have to have fair degree of certainty that a hurricane was on the way. But if you look at the commission's explanation for its good cause, it wasn't all dependent on a new hurricane. It said, given the emergency situation and the devastation to communications networks caused by the hurricane, the sooner they get more money, the sooner services can be restored. They're just saying this is an emergency in Puerto Rico. We don't even need another hurricane to justify good cause here. It's Hurricane Maria was a once in a century storm that caused devastating damage. Even after months of recovery, efforts, the majority of citizens in Puerto Rico still like access to service. That doesn't have anything to do with a future hurricane. They're just saying, hey, it's a disaster.
My reading of that paragraph,
What?
sorry, Your Honor. My understanding is that paragraph ended up and they said, these islands are still continuing to recover from the last hurricane. We're 1 month out from hurricane season. They need this money now. It wasn't because they need this money now because they're continuing.
Oh, I just read you the three sentences which say that.
The final sentence connects it to the next hurricane season starting June 1st, 2018. So it's a buildup to a month out, and they need the money now because the hurricane season is going to start 1 month later. So ultimately, the overarching reason was the annual hurricane season. The restore.
Well, that's not the way I read it. Sure, they say another hurricane could come. New hurricane services says and the next hurricane service will commence on June 1st. It's an and. So
correct, that is an and, but the buildup is to the next hurricane.
Okay.
Yeah.
Judge Edwards, Judge Garland, do you have any further questions?
No, I'm okay.
Okay, we'll hear from the government.
Thank you, Your Honors.
Good afternoon, and may it please the court. I'm Sarah Citron for the FCC. And as the court has, I think, recognized, this case turns on the agency's statutory mandate to ensure access to quality, reliable communication services in all regions of the United States. I'd like to spend a little time explaining why, in the agency's view, that was a reasonable, the decision here to, in the particular circumstances facing these territories after devastating hurricanes, it was a reasonable implementation of Section 254 to decide to subsidize communications infrastructure in these regions that would be resilient to future storms.
If you don't mind, I hate to put you on another topic, but I do have another interest here for just a moment. This is on the issue raised by opposing counsel about why wasn't Rule 54.7 waived and why Wasn't there forbearance as there was in the Katrina circumstances? When I reread the Katrina order, it seemed to me that those waivers and forbearances had to do with things that did have to be waived and forborne, like the lifeline rule and other rules. And that in this particular kind of issue about whether it covers hurricanes was not, there was no rule before that had to be forborne and no rule that had to be waived. Am I wrong about that, or is there some other explanation for why it wasn't done in this case?
You're correct that there was no rule that had to be forborne with respect to the or waived in the case of 54.7. As to the interpretation of Katrina, I'll concede that it isn't abundantly clear. I wouldn't rule out that that discussion pertained also to the high cost program, although you're quite right that the main relief in that order concerned other aspects of the universal service programs. Mm-hmm. But I would note for the court's attention that forbearance even in the Katrina order was an alternative approach. The commission first in that context clarified that this was permissible under section 254E, and kind of as suspenders that were perhaps unnecessary even in Katrina, but certainly for the reasons you suggested, Judge Garland, were unnecessary here. The commission also forbore and waived 54.7, but that wasn't necessary in the context of this case.
Okay, thank you. I'm sorry to interrupt your train of argument. Go ahead.
No, that's quite all right, of course. What I wanted to emphasize or push back on a little bit here is the characterization of Tri-County that the commission had agreed to subsidize disaster relief using their catchphrase writ large. What the commission was doing here was not funding construction of roads or hospitals or emergency food rations. The commission was subsidizing the kinds of facilities that are necessary to provide access to critical communication services.
Unless opposing counsel says otherwise, I didn't understand them to mean food or roads. I understood them to mean access to telecommunication services, and I understood them to simply be arguing that you can't do that in a disaster. That's all.
Well, and with
right or wrong, but I don't think that they were suggesting that you were providing roads.
Assuming that understanding of their argument, Judge Garland, then I think I was also hearing in several of the questions from the court the point that the statute doesn't anywhere include a carve out for when services are unavailable because of natural disaster. And I think that's quite right. So the commission here was serving its core function of applying the principles set forth in 254B to the particular circumstances in these particular territories. And it concluded that here, the best way to ensure access and continued access to these services was to fund upfront the kinds of facilities that would be resilient in the event of future storms. The territories, the record showed, are unusually prone to storms. Of course, they're islands. So
what about the amounts of money provided?
The amounts of money provided in the stage 1 order, Your Honor?
Stage 1 and stage 2.
I don't think there's a challenge to the amount of money in stage 2, except to say, I heard counsel say today, and it's part of the briefs, that the money was so large that this is going to explode the Universal Service Fund. It can't be sustained. And I, in response to that, I would just say these are defined.
I understand that, but maybe I misread their brief. You're saying that they're challenged to the amounts of money only related to stage 1?
I think they have a procedural argument as to stage 1 only, that the commission did not adequately explain the amount of money it chose, which was the $64.2 million that it awarded in emergency relief on a one-time basis. That argument, we have the threshold objection that as to this issue and all of the other issues in the case, besides the question of the commission's statutory authority, that Tri-County does not have standing to challenge.
Okay, before we are going to get to that, I promise, but as long as we're on the, we'll do it in reverse order on the amounts first. I just want to be clear. So you don't think that they're arguing that the amounts in stage 2 are not supported? It's only the amounts in stage 1?
That's right, Your Honor.
And what do you understand? What is the explanation for the amount in stage 1?
As to stage 1, the commission made what was a high-level determination based on what it saw as far as progress toward restoration from the initial immediate distribution of relief, which was of a little over $65 million, that given that progress, a roughly equivalent amount of money should enable carriers to complete the remaining restoration work in a roughly equivalent amount of time. And I think in the circumstances here, that explanation was adequate. There was a real urgency to repairing these networks, and the commission necessarily couldn't know for certain how much it would cost. This was one-time interim relief. Neither Tri-County nor anyone else has pointed to any evidence that the commission ignored or any reason to think that this number was grossly off base. And in addition, the commission didn't leave carriers with a blank check. It put in place safeguards. It specifically delineated the permitted uses of these funds. It required carriers to give certifications before and after receiving the funds. It directed the administrator of the Universal Service Fund to conduct audits. So in these circumstances, I think the commission's analysis that roughly the same amount of money would achieve the necessary remaining repair work in roughly the same amount of time was adequate.
Okay, so now if we could return to what should be our first question, which is the standing argument. You argue that Tri-County doesn't have standing to challenge the stage 1 order, right?
Yes, Your Honor.
And that's because the money was from cash reserves, is that right?
Yes.
Is it not true that if the FCC had not used, that's a double negative, if the FCC had not used its cash reserves to pay for the stage 1 order, it could have used them to lower the required contributions in stage 2 or in the future? Isn't that right?
You're right that it could perhaps have done so, but
it would have, wouldn't it? Because the regulation 45 CFR 54.709B says the contributions for the following quarter will take into consideration the projected costs of the support mechanisms for that quarter and the excess contributions carried over from the previous quarter.
I'm turning to the regulation, but I believe it also contains an exception that the commission need not do that.
Yeah, so maybe not. Maybe they wouldn't. But doesn't it seem likely that if they had the full amount of money already in excess, that there would be less of a contribution required thereafter, the next quarter?
I don't believe Tri-County has established that it's likely. And let me point you to, in particular, paragraph 19 of the stage 1 order. In paragraph 19, the commission is talking about what would happen if applicants applied for funds and a portion of these stage 1 funds, and the agency would set aside an allotment from that pool of money for a particular carrier, but then the carrier didn't ultimately qualify as an eligible telecommunications carrier, and therefore it couldn't receive the funds. What the commission said it would do in those circumstances, or that it was reserving the right to do, was redirect that provider's allocation toward other universal service purposes, such as increasing the funding available for long-term rebuilding of voice and broadband networks in the territories. And so the commission was signaling that it might well increase the size of the long-term fund, the stage 2 fund, or it could have put that money toward other universal service contributions. So I don't—
Right, but it could only put it towards the uses that are authorized by the statute. And if it already had the money for those uses, it couldn't just, it's not like it's unlimited how much they can, the FCC can increase contributions. It has to be based on a need for the money, doesn't it?
That's right, Your Honor.
Right. So
I don't.
If they have an extra, I don't know, $1 billion, doesn't it suggest that yes, it's possible that there will be more needs and new needs, but there'll be $1 billion more money available for those more needs and new needs?
Perhaps, Your Honor, and I don't want to belabor the point. I just want to say, with respect to this amount of cash reserve, it was created by a system of uniform contributions that was a time-limited program. In the ordinary, the way the Universal Service Program has run historically before the 2011 reforms and how it continues to operate today, collections are made based on projected demand 1 quarter out. So this was an unusual circumstance where there was this cash reserve, and it was created by the commission in this time for a time-limited period to account for special needs that arose during that period.
I still don't see how that has any effect on the standing argument. If you do have the money for whatever reason, the money was there, and that would reduce the amount of money needed for expenditures. No matter how many further expenditures you think you need, you still have to subtract the amount that you already have. And that suggests you don't need a new contribution for that amount, whatever it is.
I think that that's not the way this would have operated necessarily. I concede that it's possible it would have operated that way. And that is just because Tri-County's contributions and the contribution factor for this program was fixed for the period through the end of 2018. And then and that was the period of time during which the commission contemplated using these cash reserves. So I don't think Tri-County has established a substantial likelihood that had there been no need for the funds during that period, the commission would necessarily have rolled them over to reduce the contribution factor in future quarters. But I'd maintain that at any rate, the commission's stage 1 order should survive on the merits, and I'm happy to address merits questions you may have. There were, in the discussion of notice, I'd just say I would agree, Judge Garland, with your point that this was not an emergency of the commission's making. And I think Judge Tatel recognized that the commission in paragraph 24 of the stage 1 order made clear that it was responding to an acute problem that which Tri-County does not dispute, that communities in these regions lacked access to critical communications services during this period. And so the commission reasonably addressed that as an emergency and determined that the good cause exception, though narrow, applied because further delay would prevent people from having access to these necessary services. And I don't think it undermines the commission's analysis on that point, that it also recognized that a new hurricane season was approaching, but the paragraph does say, and a new hurricane season was approaching. It isn't the case that the commission rested solely on that point. If there are no further questions, I'd ask that the petition be dismissed as to the stage 1 order, but otherwise denied.
Thank you. Mr. Adamczyk, I think you were out of time, but you can have 2 minutes.
Thank you, Your Honor. I would like to address the standing argument that the FCC's counsel brought up.
Which standing argument? Are you talking about the allocation issue or the one Judge Garland was pursuing?
The usage of the high cost account reserve fund.
Oh, okay.
The high cost reserve fund is intended, as was previously discussed, to take excess contributions and apply them to 4 quarters to offset demand. If the FCC had a sufficient amount of money to do that, then they could address other issues, other initiatives. Clearly, here, what happened was the FCC said by December 8, 2018, the reserve account was depleted from all these other projects that were going on. So they weren't using it as the primary purpose of that account was. They had circumvented the primary purpose and focusing on all these other initiatives, and they ran out of money in the fund. They said in 2018 that we ran out of money in the fund, and we direct USAC going forward to make sure that there's enough contributions going forward to focus on the purposes of that fund. So by the time the stage 1 order was issued in May 2018, made no mention of using the high cost cash account in that order. And then 3 months later, they direct USAC to pay out the stage 1 funding from the high cost cash account. And then by the end of that year, they admitted that the funding wasn't there. So clearly it had an impact going forward on USF contributions because it wasn't being used for its primary purpose. So for that reason, TCT has standing because the fund wasn't used to offset future contributions. And while all this was going on, future contributions skyrocketed to where now we're at.
Can you tell us, excuse me, can you tell us the citation at the end of 2018 where they said, we've run out of money and now we need to increase contributions?
Yes, Your Honor. I believe I have that citation in my reply brief.
Okay, just tell me the page of the reply brief. That'll be sufficient.
It was on. Sorry, Your Honor. It was on page 6 of the reply brief.
Okay, thank you.
If there are no further questions, TCT requests that this court reverse and vacate the FCC's decisions. Thank you.
Thank you.
Thank you. Case is submitted.
This honorable court is now adjourned until Friday, October 16th at 9:30 a.m.